Before we begin the arguments for this morning, I'd like to inform the members of the bar of a very unique initiative of the Supreme Court. We have prepared a handbook on combating gender stereotypes to assist judges and the legal community in identifying, understanding, and combating stereotypes about women in legal discourse. It contains a glossary of gender unjust terms and suggests alternative words or phrases which may be used while drafting pleadings as well as orders and judgments. So it reaches out to lawyers as well as judges. The handbook identifies common stereotypes about women, many of which have been utilized by courts in the past, and demonstrates why they are inaccurate and how they may distort the application of the law. The intention is not to criticize or cast doubt on past judgments, but merely to show how stereotypes may unwittingly be employed. To raise awareness against the utilization of harmful stereotypes, particularly those prejudicial to women, the handbook aims to explain what stereotypes are and helps judges identify and avoid such stereotypes by, firstly, identifying language that promotes gender stereotypes and offering alternative words and phrases. Two, identifying common reasoning patterns that are based on gender stereotypes, particularly about women, and discussing why they are incorrect. And three, highlighting binding decisions of the Supreme Court of India that have rejected these stereotypes and can be utilized by judges to dispel gender stereotypes. So it's been, you have the first page of the document here on the screen, and it's uploaded. It will be uploaded very shortly in a minute or two on the website of the Supreme Court of India. We have also uploaded on the website right now the manual and FAQs for e-filing. And in a couple of days, we'll be also uploading simple video tutorials on how to do e-filing for members of the bar who just require a little bit of hand-holding on that. So that's all. It should be here on the website in a minute now, or a few minutes. Thank you. Thank you, Dr. Guzman. Yes. No, but you know, Mr. Dwivedi, if you start using it, you'll find it so simple actually.
But now you find hampered because of the potential. Because certain things that come up, I feel you're not having adequately.
Please do answer them in your submission. No difficulty.
It requires addition.
No, addition you will know. We are making notes, so you can always make the addition in your oral arguments. You know, Mr. You know, Mr. Dwivedi, I'll give you a concrete example. I'm in the process of sort of formulating a judgment. We are still, now it's almost done, on Hindu law as to whether a child born from a voidable marriage is entitled to a share in the ancestral property. So today, I mean, over the last few days, I've opened the file. We didn't have any such limit as we have now imposed here. 3 or 4 written submissions by each member of the bar, 3 or 4 compilations by each member of the bar. It's impossible to sit down to dictate a judgment because, you know, you have judgments of different genres and different submissions coming up, and it becomes impossible for the judges to write judgments. So today in the morning, I was telling my secretary, I said, we first need to now look at all the judgments, prepare a separate file, put them in chronological order. But even then it doesn't help because you have marked what was being read out by the lawyer. So, you know, this is the real problem which we face.
There are 2 issues. Judicial precedents were never in such large volumes as it is available today. Go back 10 years even. Number 2, the concept of giving written synopsis was comparatively not there. Everything used to be argued. We used to take down notes and dictate. Now, the purpose of a submission or a synopsis, as I understand, is to facilitate in dictating the judgment. Instead of that, it becomes so much more cumbersome that we don't know who is saying what, where. These kind of pleadings of thousands of pages used to not be filed. So that's, there are many cases of this category. No. At rethinking, they are certain.
Trivedi, my take on this has been, if the homework in the office is thoroughly done, normally this problem doesn't arise.
It can never be complete.
It is possible to do.
The judgment can never be complete. The judgment can never be complete. The thought process will continue from your side.
You know that
It will continue from our side.
my fear always as a judge is that in this process, I've missed out some very important point of judgment because it's all, sort of placed in different silos. That's what is really worrying for us as judges. This about reading, trying and collating can always do that. Can tell our law clerks to put all the judgments together in a chronological order. Danger is you feel that, oh my God, I might have just missed something because things come in, driblets over a period of time. Supreme Court gives 30 minutes time and 1 hour's time. So we need to now just...
The US Supreme Court do it in 30 minutes. The most complicated case, they only hear you for 30 minutes, including time interventions of the court.
No, we are far more advanced technologically. Actually, trust me, we are almost at the high end of the curve in India.
Part of habit action.
Yes. So that we can just keep it on the dais, as the hearing. That will be very useful. Naika Bhushan. Yes, that you want to refer to. Again, refer to. That's very useful. Oh, you have also put it in a plastic. Oh, excellent. Yes, Dr. Bala.
No library talk this time, my lord. But start again, my lord. I appear for the JK People's Conference, my lord, in Writ Petition 1165 of 2019. A question that your lordship put to Mr. SAFESAL was, have you challenged the presidential proclamation of 19th December? We've challenged the suspension, my lord, and that is very important to our argument on Article 3. There is also another petition, my lord, Sohail Qureshi 1068 of 2019, which actually challenges the proclamation.
2068, right?
1068.
Yes.
Now, my lords, I would begin by saying, as well from my lord the Chief Justice, that this oral submission is in the nature of a dialogue, and a very important dialogue, which even the US Supreme Court doesn't have. They assume everything is read, and there's a bit of question and answer, and that's it. And it is because of the nature of the dialogue, we have to, on an ongoing basis, answer what fell from your lordships as well. I'll give your lordships an example. My lord, the Chief Justice made a reference to 249 and 252. Of course, they are of a different genre. But nevertheless, my lord, that question is very, very important for us to build the diversity argument and whether there is transformative constitutionalism, whether there is a basic structure, whether that's a lost cause or not. Then, my lord, your lordships had asked questions about Article 3(1)(d) and whether Article 370 subclause 3 survives. Now, this is important because it's been used only twice. It was used in GO 44, my lord, and now it has been used once again in GO 273. Now, if it doesn't survive, my lord, how can it be used in this particular way? We have to answer that question for your lordships. In addition to that, my lord, there seems to have been some confusion or misunderstanding on the status of merger agreements, my lord. The question that fell from your lordships was that once the instrument of accession is over, sovereignty is complete. Our respectful submission, my lord, on this, which I will elaborate. I've done it in a note, my lord. Like Mr. Zafar, I'll hand over that note, my lord, to your lordships. My lord, 3.7, as far as the instrument of accession is concerned, it deals with external sovereignty. Kindly bear this in mind, it's very important. External sovereignty is lost. With a few exceptions here and there. But internal sovereignty is not lost. That is why in Premchand, they say the monarch was still an absolute monarch. Premnath Kaul, sorry. Somewhat the purpose of the standstill agreement was, what system would you have in the meanwhile? The state of the Raja of J&K didn't sign a standstill. The records show there was some toing and froing and eventually, which means he retained all his power. So as far as internal sovereignty is concerned, the standstill was very important because all the powers of the Maharajas and the coming states, my lord, retain their internal sovereignty. Now come to the merger agreement. The merger agreement is important, my lord, because it finally indicates the extent of internal sovereignty. If there was no standstill agreement, and if there was no merger agreement, my lord, the Maharaja would be absolute, as Premnath Kaul says. So I take 370 to be, my lord, a substitute, a constitutional substitute for a standstill and merger agreement, without which, my lord, we are lost. And I'll explore that, my lord, later when I come to 370. Your lordship also, my lord, put a question to Mr. Zafar Shah that on the 4th of August, what were the autonomies that you were going to lose? He promised you a list, my lord. One answer to that is everything, but I will indicate what these autonomies meant and what was lost for Jammu and Kashmir, which comes back to Justice Kaul's question, are we flogging a dead horse? The answer is no, my lord. It continues and it has to continue to preserve, my lord, the federation and the conditions under which the federation was created. So let me begin with what I began with the other day, my lord, and that is that we have the greatest diversity in the world. Take many continents together, take many countries. This diversity is unparalleled. That is why, my lord, Professor Ravinder Kumar, I asked him, I said, what should I say in my Colombo lecture? He said, say that the Constitution of India is a constitution for a civilization with many nations and many cultures. And this is what makes our Constitution more exciting than any other. On the question of diversity, I was taking your lordships to, where is my other note? Just reading it. I have, my lord, done a list which I'll give to your lordships, my lord, but I was going to invite your lordship's attention to Article 3 first. principle of Article 3, my lord. But I'm going to read one important aspect of it, my lord. And that is the proviso which says that before anything is done under Article 3, it is mandatory for the President to refer the bill to the legislature. Mandatory. It's a condition precedent before you invoke Article 3. Just as there are conditions in Article 370 which have to be fulfilled by condition precedents. Now on Article 3, my lord, the proclamation of 19th December virtually created an amendment of Article 3 by taking the condition precedent out. Mr. Sybil read all that to you, but I want to refer your lordships, my lord, to that particular part of the proclamation. My copy, somewhere here. Your lordships will find this, my lord. Like Mr. Dwivedi, I have no problem with what your lordship is doing. We just have to learn and catch up, my lord. This your lordships will find in volume 3 documents.
Page 92.
And the PDF, my lord, I'll just give it to your lordships.
Page 92.
PDF 92. Now, my lords, I want to take your lordships straight away, and it's very important that we should.
Sanjay Miller. Page. Ultimately, everything boils down to this. Of course, the Constitution itself, and but so far as documents are concerned, in one page now we have. In case something is missed, you can tell Mr. Dr. Dhawan's instructing advocate. They'll just put it in and what do we call this? This plastic made up.
Divine fire. Your Lordship will see that there is a condition precedent in Article 3. And this condition precedent, my Lord, was added to by CO 48, which I'll show to your Lordships in a moment, my Lord. Which further required the bill to be sent to the legislature of the state, but we're not concerned with that because it has to be sent to every single state. Now, my Lord, I take your Lordships to this notification C subclause 2. So much of the first proviso of Article 3 of the Constitution as relates to the reference by the President to the legislature of the state, and the second proviso to that article, so that much of Clause 2 of 151, which is about audits, my Lord, of the Constitution as relates to laying before the legislature of the state of the report submitted by the Governor to the Controller Auditor General. You will see that the opening sentence is the following provisions are suspended. In other words, my Lord, a mandatory provision of Article 3, whether it applies to Kashmir or elsewhere, my Lord, is suspended. It's not a question of just laying before Parliament as a substitute. Article 3 and Article 370 does not tolerate substitutes. Now, my Lord, what does this do? This is not, my Lord, that can be done under a proclamation under 356. It is a constitutional amendment which is subversive of the Constitution itself. If this suspension fails, my Lord, President's rule will fail. And its extension, my Lord, in July will also fail. You have amended the Constitution, albeit to all states and certainly to Jammu and Kashmir. And this mandatory provision takes us to the core of the mandatory requirements, my Lord, of Article 3. Because the entire JK or Reorganization Act emanates from Article 3 and Article 4. Take away this condition, my Lord.
How do we deal with this Article 356(1)(c)?
Sorry, my Lord.
Article 356(1)(c) says that if he may make a proclamation where a situation has arisen that the government cannot be carried on in accordance with the provisions of this Constitution in any state, and then C.
Make such incidental and consequential provisions as appear to the President to be necessary or desirable for giving effect to the objects of the proclamation, including provisions for suspending in whole or in part the operation of any provision of this Constitution relating to any body or authority.
So the President has a power to suspend certain provisions of the Constitution during the operation of a proclamation under 356.
The suspension in this case goes beyond supplement, my Lord. It goes to actually taking out a mandatory provision. Of course, my Lord, Article 4 says that any change that is made will be treated as not requiring an amendment. But leave that aside, my Lord. How is 3 and 4 to operate after this? The presidential duty, my Lord, has to be a little more careful Because this was tailored way back in 19th December 2018 to start a process, my lord, of amending the constitution for the purposes of which
Normally when the legislature, here of course it's the constitution, uses the expression means and includes. Here it's not means, but it says make and includes. When means and includes is used by the legislature, it's an indication of expanding the power. So when the constitution says, it begins by saying make incidental or supplementary provisions,
yes,
and then says including. So this including seems to be to widen the ambit of what was stated earlier. Namely, the earlier part says you will make incidental or supplemental provisions. But then it says including. So including would mean that what was otherwise not a supplemental or incidental provision is within the ambit of the presidential proclamation, isn't it? Because suppose the clause C read just up to proclamation and didn't have and including. It's not and including, it's including.
that's right.
Suppose it ended with the word
whole or in
proclamation.
part the operation of any provision of the
So
constitution.
if the last part of Article 356(1)(c) was not there, you could have challenged any amendment of the Constitution on the ground that you don't have the power to make an amendment of the Constitution in the guise of making an incidental or supplemental provision.
Lord, this is the basis of our challenge, my lord. In our petition, we have challenged only the suspension.
My question is this: suppose the President in a proclamation suspends the operation of any provision of the Constitution. Is that amenable to a challenge on the ground that it is not incidental or supplemental? Or are these words of widening the ambit of the first part of 356(1)(b) so as to be immune from such a challenge?
This, my lord, has remained within the limits of 356. That is, for the governor, you read the president. For the legislature, you read the legislature. But I've never seen a provision in any proclamation, my lord, throughout, my lord, these decades, which actually uses the supplemental and including. I've never seen it take away a mandatory provision of the Constitution. This is exceptional, my lord. Now you can read it together in one way, you can read it together in the other way. If you expand 356(c), my lord, then you will say that the president has a carte blanche to amend any part of the Constitution as part of the supplementary provisions.
Can you, for example, say that there'll be no judiciary in the state?
That's right, my lord.
That's what you're
That may be covered by the proviso, but at any
right.
rate.
Oh yes, the proviso
So,
says, of
Lord,
course.
supplementally, this 356(c) has to be read with the mandatory provisions which it cannot dilute.
But actually the proviso, Dr. Dhawan, the proviso seems to indicate that if Parliament, if the Constitution wanted to exclude a particular power from the authority to suspend a provision of the Constitution, then that has been specifically defined. So the proviso says that you will not suspend anything pertaining to a high court, or you will not assume to yourself as the president any of the powers which are vested by the Constitution in a high court during the operation of a proclamation under Article 356. So where it wanted to introduce a restraint on the presidential power, it has done so in the form of the proviso.
Right.
Do we now say that, well, apart from the proviso, there may be certain other parts of the Constitution which the president cannot suspend?
No, that is,
Or would that be reading into Article 356 words which are not there?
not
Just one. I think coupled with the words appears to the president to be necessary or desirable for giving effect to the objects of the proclamation.
yes,
So there has to be connect and a nexus with the object of enforcing the proclamation. That's a restriction.
it must relate to 356. In other words, whatever is required to materialize 356, it must be related to that. And therefore, my lord, these words necessary or desirable are not carte blanche powers of the president. Could he have, under these provisions, suspended Part 3? It has been done, my lord.
Part 3?
That fundamental rights, directive principles. Could he have done all that, my lord? Therefore, my lord, it has to be given, even with the caveat of regards the High Court, it has to be given a limited meaning where your lordship finds that in every state that has been created under Article 3 and 4, this has been treated as a mandatory provision. There is a caveat that your lordships have imposed on Article 3 and 4, that all that it requires is a reference to the legislature, and the union is not bound by it. Those, my lord, when I come to my written submissions, I'll run through them very fast because I don't need to, my lord, take out the books or refer to the cases. This, to my mind, my lord, taints the entire process. Gopal Shankar Narayan, my lord. On the inclusion provisions for suspending in whole or in part the operation of any provisions of this Constitution relating to any body or authority of the state. And then a colon. This further subscribes the extent of the presidential proclamation. Otherwise, my lord, 356 is an exception. It overrides federalism. It collapses democracy in a state. Because if the presidential proclamation does something that is irreversible, and that is a test your lordship will use. And Justice Khanna is right, my lord, when he emphasizes necessary or desirable. In relation to body and authority, as I pointed out. If this proclamation is bad, then its extension, my lord, in July is also back. Because that was a parliamentary extension for a further 6 months.
Yes.
Now, my lord, Article 358 suspends Article 19 during the proclamation, not beyond. This is now, my lord, and your lordships will see that further when I present CO 272 and 273. They go well beyond the period. And the genesis of all this, my lord, is the presidential proclamation. Even assuming, my lord, it goes for 1 year, it takes away conditionalities which cannot be taken away. Later, my lord, I'm sorry. I'm a little loud. I'm not used to whispering into microphones, like my predecessors. Now, my lord, I'm going to place. No, classrooms are very soft. Classrooms are a wonderful exchange with students, unparalleled, just as this is an exchange between the bench and us, my lord. And it is the nature of this exchange, my lord, that we must honor, under limitations of time, of course, my lord. But we must, my lord, honor this exchange as the most important part of arguing in this court. Now, my lord, in Article 3, CO, just want to point out the CO number. Now, your lordships will see that because your lordship raised the question, what did you lose on 4th August, after 4th August? The CO 48, the PDF is 485. PDF 13, my lord. Take it out there. Going to have nightmares about PDFs, my lord. Now, my lord, if your lordships were to come to page 10 of volume 3, 406, sorry, not external, and PDF? PDF 13.
13. Same volume.
Same one.
1954.
This is the
1954.
54 order. My lord, in a sense, the 54 order and 370, my lord, represents the constitution as relates to Kashmir. They were brought in by the Constituent Assembly. Now, I'll just read out that particular portion, my lord. so that I complete the 3-4 argument before I go into the business of how elaborate our constitution is. At the bottom of that page, my lord, 406, provided further that no bill providing for increasing or diminishing the area of the state of Jammu and Kashmir or altering the name or boundary of that state shall be introduced in Parliament without the consent of the legislature of the state. It puts in a conditionality, my lord. Not just to circulate it, but a conditionality, my lord, emanating from the state itself. Now, whether all this can be wiped out by CO 272 and 273 is another matter. I'm going to make one further proposition, my lord, about President's rule. Lest I forget, I'll refer to it later, my lord, if I can. Now, my lord, the further proposition, which is a wider proposition, is this: that during President's rule, Article 3 and 4 and 370 cannot be invoked.
Article?
Cannot be invoked.
Article 3 and 4.
3 and 4, my lord. Why? Because they have conditionalities, my lord. And the conditionality is specific to the legislature of the state, to the government of the state. And the legislature becomes Parliament. The governor becomes the president. Therefore, the conditionalities that exist in 3 and 4 and Article 370, neither Parliament, my lord, nor the president can be substitutes for the conditionalities that exist in Article 3, 4 and 370. You don't go through that process.
Dr. Dhawan, is such a broad proposition with regard to Article 3.4. Forget about 370 for the time being. May not be correct in terms of the language used of Clause 3 to 356. Let's hope it never happens, but in a given case, it can happen. There can be disputes between two states, and which is impossible to resolve until unless the center steps in with regard to boundary or something. So broad proposition, if you're making a broad proposition like that,
I'm responding.
it's very difficult. It's very difficult to accept.
I'm responding.
Because we can be varied situations which we may not be able to postulate as of today.
Well, I'm making about a proposition about process and substitution. Because 370, subclause 1, my lord, has its discipline. Just as 3 and 4 has its mandate discipline.
Leave 370 for the time being, but a broad proposition that Article 3 and 4, the provisos can never be suspended in terms of Article 356.
My lord, the Parliament cannot be, and I'll show the debate when Amit Shah introduced this, my lord, in the Lok Sabha. Parliament cannot be a substitute for the legislature of the state. That's a very narrow proposition, my lord. I've been prompted, my lord, nicely. And when Mr. Sibal talked about the political uses and abuses of the Constitution, then Proclamation 19th December, my lord, is an abuse of the Constitution, and it would be a further abuse of the Constitution if we substitute for legislature Parliament.
Dr. Dhawan, there's difference between existence of power and abuse of power or use of power.
Of course, my lord.
So let's not confuse the two.
Sorry, my lord?
There's a difference between existence of power or use of the power or abuse of the power.
No, my lord.
So let's not.
There is a power, no doubt. Its exercise is equally fundamental. We can't wish away the exercise as being purely nominal in nature. Now, my lord, when Maharashtra was broken, and the judgments are all there in my written submissions, I'll take your lordship very fast through them. They said you have to refer whether you like it or not. Likewise, Punjab, my lord. You have to refer the bill to the legislature of the state. You can't self-refer it to Parliament. And the Constitution says no bill can be introduced, my lord. It's a complete bar, my lord, because we have to understand the limitations of President's rule. And this is one of the important, my lord, limitations, that during President's rule, you may have the power to do whatever you want in 3(4) and 370. But the process, my lord, are conditions which can't be substituted by simply saying the governor will now become the president and the legislature will become Parliament. This process of substitution, my lord, is subversive of the Constitution.
Dr. Dhawan, can Parliament enact a law during the subsistence of a proclamation under Article 356 in exercise of the power under Article 246(2) or in respect of a stateless item?
Look, they can pass a law, my lord. No doubt about that, subject to all the limitations that exist.
Right.
Except, my lord, there is, when it passes a law under Article 3 and 4, it must observe the conditionalities.
In other words, what you're trying to, your argument would be this, that while Parliament can exercise the lawmaking power of the state legislature during the subsistence
With all
of
its
the proclamation-
limitations.
Yes, with all
The
its
state
limitations.
list comes to them.
The state list comes to them. But certain other functions of the state legislature, namely in terms of the first proviso, to discuss a legislative proposal for altering the boundaries of the state, or under the second proviso for giving consent, that power can't be assumed by Parliament.
Lord,
Because then we are creating an exception to the language. I mean, you may possibly argue that you have to create that exception to give a purposive interpretation to that provision. But this one part is very clear, that to accept your argument, we are then creating an exception to 356(1)(b). Because 356(1)(a) says that the powers of the state government are vested in the president or in the governor, as the proclamation would say, other than the powers of the legislature of the state. Then 356(1)(b) says, declare that the powers of the legislature of the state shall be exercisable by or under the authority of Parliament. So we will then, to accept your argument, we have to then hold, of course, maybe by a process of construction, that those powers which are referable to Article 3 and 4, which are powers of the legislature of the state, no doubt they are powers of the legislature of the
the
state.
difference between the legislative powers of the and the consultative and other powers of the legislature. If your lordship will see 357, my lord.
But it says, declare that the powers of the legislature of the state. Now, which are the powers of the legislature of the state?
Legislative powers. My lord.
Not just the powers under Article 246, but it could be all the powers of the legislature of the state which are vested in the Constitution. Would that be not a more natural construction?
Take your lordships to Article 257, subclause 2. 357. Sir. (357)(1), my lord, declares that the powers of the legislature shall be exercisable by or under the authority of Parliament. It shall be competent for Parliament to confer on the President the power of the legislature of the state to make laws and to authorize the President to delegate, subject to such conditions as they may think fit, the power so conferred to any other authority. For Parliament or the President or any other authority in whom such power to make laws is vested under subclause A, to make laws conferring and imposing duties or authorizing the conferment of powers and the imposition of duties upon the union or the officers and authorities thereof. For the president to authorize when the people, House of the People is not in session, expenditure from the consolidated fund of the state pending the sanction of such expenditure by Parliament. More important, the law is to any law made in the exercise of power of the legislature by Parliament or the president or other authority referred to in subclause so and so, which Parliament or the President or such authority would not, but for the issue of the proclamation of 356, have been competent to make after the proclamation has ceased to operate, continue in force until altered or repealed or amended by a competent legislature. Which is the competent legislature? So, my lord, even as regards the functions of Parliament, they are specified 356 is not plenary in nature. It's important to understand that. It is the bane of the Indian Constitution, my lord. It's introduced again and again and again. In fact, the Indian Law Institute, I was reading the 1935 debates, my lord, where Churchill interjects and says, create the situation in every single province. Now, my lord, 356 has been used and abused to a point where there must be some discipline to it. It is certainly not, my lord, a power to amend the Constitution. Let's leave it there. Not transferring executive and parliamentary functions, that is the power to legislate alone, is the core of 356 and 357. There are many provisions in the Constitution, I have a list here, my lord, where legislatures exercise many other kinds of powers as well, my lord. Powers of election, powers of negation, powers of consultation. So it has to be limited, my lord. Otherwise, my lord, what happened in the 5th August onwards, my lord, can happen to any other state during president's rule.
Dr.
That is why the broad proposition.
Legislatures exercise other powers. You said consultation. Which were the other ones? I just missed that.
My lord, I have a list here. Article 3, for example, my lord.
So how do we conceptualize those other powers? Consultation, you said you used that some phrase which I just lost. You said legislatures exercise other powers.
There are legislative powers which emanate from.
That's 246.
Article 245, which says subject to the provisions of the Constitution. And it's important, my lord.
What are the other powers that you said? You said consultative.
Article 3 is a consultative power to express views. Article 54 is the right to vote in presidential elections. JK was not able to participate, my lord, in the last presidential election. Article 80 is to elect members to the Rajya Sabha. Article 169 is to pass a resolution for the creation of legislative councils in a state. Article 171, 243M, my lord. I'll come to those because I want to go into the question of the diversity of the Constitution.
243M.
Then, my lord, 243M. Then, of course, most important, my lord, list of them, I'll give it to your lordships, my lord. I think it's better. But the important part is it's limited to the legislative powers. It certainly cannot amend the Constitution. Or I'm going one step further, or deprive the Constitution of its mandatory processual requirements. It's an argument about process and power. And this, in my submission, my lord, taints, my lord, also the extension of president's rule.
That
It was
point you have made,
done by Parliament, which I've already indicated to your lordships. This is fundamental, my lord, to how this process of diluting 370 occurred and how Article 4, my lord, eventually got used with all these incidental provisions, which were limited to legislative powers and none other. Now, my lord, I wanted to get back to the point that I started with, my lord, about the diversity of the Indian Constitution. I'll quickly take your lordships through it, because your lordship is concerned with how this diversity can be preserved. Bodoland, my lord, is mentioned in the Constitution. Nagaland has, my lord, and others have autonomous councils. Well, I'll take your lordships through them. Now, my lord, if this can be done under President's rule, anything can happen. Yes, they look much. What I've done, my lord, to save time, is I've prepared a list of the articles that take us to diversity. I'll quickly run through them in the Constitution itself. I know your lordship doesn't like paper being handed over, my lord. But we can put it on the website, my lord.
This is acceptable because these are only articles of the Constitution.
Quite right, quite right. My lord, it saves time. It saves time. That permission is permissible. Because when your lordships didn't permit Mr. Sibal to give supplementary submissions, I thought that's a harshness that might be imposed on handing anything over to the court. Now, my lords, come to Article 2, my lord. This is important, my lord. It's Parliament's power to admit to the Union new states on such terms and conditions as it thinks fit. This is very, very different, my lord, from the assimilation, my lord, of the princes, etc., into the Constitution. That is, you go through an instrument of accession, you go through standstill, you go through merger, which then determines what is really entered into. Of course, my lord, in Podial's case, the majority judgment of Justice Venkatachalaya takes into account the entire history of the negotiations and says that although the Constitution says one person, one vote, nevertheless we will permit reservations for Bhutias, Leptas and the South. In the context of that history, we will nevertheless permit it. And there were two dissents, my lord, by Chief Justice Sharma and Justice Agarwal. Now, Podial reminds us that these negotiations are important, even though it says as it thinks fit. 2A was removed, my lord, in the Constitution because Sikkim was given associated statehood first. Now, my lords, kindly come to 3, which I've dealt with, 3 and 4. Then, my lord, kindly come to a very interesting provision, my lord, when we were dealing with affirmative action. That's Article 35. Prepare a proper list and give it. Identify to be more. Now, this is a very interesting provision, my lord, relating to Article 16(3). I'll just read it, my lord, because it's important. Notwithstanding anything in this Constitution, Parliament shall have, and the legislature of a state shall not have, power to make laws with respect to matters in Article 16(3), 32(3), 33, 34, or for prescribing punishment for those acts which are declared offences under this part. And Parliament shall, as soon after the Constitution, make laws prescribing punishment. Laws immediately. Now, here's a very interesting provision, my lord. In relation to affirmative action, the power of the legislature is taken away. To change this, my lord, would require an amendment to the Constitution. Two judgments have dealt with it, my lord, which have dealt with, my lord, Andhra Pradesh and Jharkhand, but we needn't go into that. Then, my lord, if your lordships will come to Article 164. Got it. All done. I pointed this out on the other day, my lord. These are safeguards, my lord, for the federal unity of India. As indeed was 370 for the federal unity of India. It is part of the basic structure of federalism in our Constitution. When I was formulating this argument, I was told their lordships might be averse to a basic structure argument, so don't make it too strongly. So I'll stay within my limits, saying these are limits that a Constitution has in relation to federalism. Now, 164, my lord. I've given your lordships a list. I'm going around the list where taking your lordships through the important provisions. Article 164. My lord, has a proviso. Provided that in the states of Chhattisgarh, Jharkhand, Madhya Pradesh, and Odisha, there shall be a minister in charge of tribal welfare who may, in addition to be in charge of the welfare of scheduled castes and backward classes or any other work. My lord, this, if it is to be changed, requires a constitutional amendment. Can't be done under President's rule saying we will have this minister or that minister. Then, my lord, if I may take my lords, my lord, to 168. Which empowers the legislature, my lord, much in the same way, my lord, as the JK Constitution empowered the legislatures. Article 169, my lord. 168 and 169. This relates, my lord, to whether there should be two houses in Parliament or not. Finally, bear in mind, Jammu and Kashmir had a legislative council under its constitution. I'm reading, my lord, 169(1). Notwithstanding anything in Article 168, Parliament may by law provide for the abolition of the Legislative Council of a state, having such a council, or for the creation of such a council in a state having no such council, if the Legislative Assembly of the state passes a resolution to that effect by a majority of the total membership of the Assembly and 2/3, my lord, of those present and voting. In our case, my lord, the Legislative Council is gone. Well, actually, the whole of the JK Constitution is impliedly gone. Where was the power to do away with that? But that's another question that I'll come to, my lord. Then, my lord, kindly come to Article 239. I had earlier said, my lord, the other day, that most of the union territories, other than Chandigarh, were created by constitutional amendment, or under the aegis of a constitutional amendment like the 6th Amendment. (239A), my lord, deals with how union territories are to be created and the creation of local legislatures. This can't be given the go-by, my lord. Parliament may by law create for the union territory of Puducherry a body elected partly or partly nominated, partly elected to function as a legislature and a council of ministers, or both with such constitution, powers and functions in each case as may be specified. Now, my lord, compare with what has happened in the case of J&K. State has become union territory, my lord. 2 union territories, one without a legislature, one with. This was not within the remit of Article 3 and 4 as an incidental provision, my lord, where you lose your character as a state. And there are 2 union territories that have been created, not by reference to Article 239A or 239AA. If you wanted an elaborate constitution put in place, as in the JK Reorganization Act, you should have done what is done with Delhi. The council disappeared. Now, my lord, your lordships are very familiar with the 2 Delhi judgments, my lord. I'm going to refer to passages of it because they deal with diversity. But when I read my written submissions, my lord, they'll be there. I won't have to ask your lordships to PDF. Now, my lord, come to Article 240. Power of the president to make regulations for certain union territories. Puducherry is mentioned, my lord, as E. Do we add JK, my lord, and Ladakh to it? Because if 240 is applied to JK, as it must be, my lord, it's a union territory now. Or perhaps that has to be added by constitutional amendment. But, my lord, the president will make regulations for peace, progress, and good government of union territories. Is this applicable, my lord? If so, my lord, it undermines not just federalism, my lord, but democracy itself. Now, my lord, may I take your lordships to 243, particularly to 243M and 243ZC. What 243M says part of panchayat, so fundamental to three-tier federalism, shall not apply to certain areas. I'm just showing the diversity, my lord, that exists. Now, my lord, if your lordships will come to subclause 2(3)(a), this will not apply to the district of Darjeeling of West Bengal, for which the Darjeeling Gorkha Council exists under any law for the time being in force. Even the panchayat amendments, my lord, have been curtailed in this balance of federalism. Not, my lord, by any executive exercise. And then, my lord, 3A, that it won't apply to Arunachal Pradesh. And then once again, my lord, here is a non-legislative function, my lord, in Article 4. Legislature of the state may by extend this part to the state except the areas referred to in clause 1. If the legislative assembly of that state passes a resolution to that effect by a majority of the total membership of the House and by a majority of not less than 2/3. Here is once again a provision, my lord, the most fundamental exercise of three-tier federalism, my lord, which is a part of our constitution. Then, my lord, ZC, 243 ZC, says the same thing, my lord, about the Darjeeling Gorkha Hill Council. First, my lord, 243 ZB, my lord, which is about municipalities. It applies to union territories which have a legislative assembly. What happens to Ladakh? (243 ZC), my lord, has similar provisions as regards municipalities as it does to panchayats. In relation to the Darjeeling Gorkha Hill Council. (275), my lord, very fast. Sorry, 244, my lord. This is, my lord, dealing with scheduled and tribal areas. None of this can be wished away, certainly not by executive action, my lord. It is so crucial to understand this diversity of our constitution. 244 says, administration of scheduled areas and tribal areas shall apply to the administration and control of scheduled areas in any state other than the states of Assam, Meghalaya, Tripura, and Mizoram. And then 244A is a very important provision, my lord, because it relates to autonomous states. Our constitution, my lord, doesn't shy away from creating autonomous states, my lord. In fact, it reinforces them. And if there was that measure of autonomy, my lord, in JK, then it is not inconsistent with so many provisions in our constitution which respect autonomy for what it's worth in special areas. 244A, my lord, is very important. And when I come to Schedule 6, because if this can be done, my lord, under President's rule, place any under President's rule, expand it beyond the legislative function. Simply can't be done, my lord. These are mandatory provisions of the Constitution. 244A, formation of an autonomous state concerning tribal areas in Assam and the creation of local legislative councilmen. Parliament may by law, from within the estate of Assam, an autonomous state comprising whether wholly in part of tribal areas. Autonomy, my lord, of the states is fundamental to our Constitution. I rely on the two daily judgments, my lord, of your lordships to reinforce this. Where your lordship respected, my lord, the autonomy of the legislatures and their existence. Those passages I'll show to your lordships very fast, my lord, because they're in my written submissions. Autonomy, my lord, is not alien to our Constitution. You can't just standardize, my lord, all the provisions and say, look, we give autonomy here, but we're not going to give autonomy to J&K. Why? Because on 19th December, we took away a provision. J&K is not a dead horse, my lord, to be flogged or not to be flogged. It is the constitution of an autonomous region through the merger agreements which are part of 370. I'll come to 370 in a moment. It's very important to understand and not wish away the autonomy in Indian federalism. Then, my lord, if I may take your lordships, my lord, to 275. It has special provisions, my lord, made in 275, subclause 1A. Check with it. Can I tell them you are my guru? Now, my lord, kindly see what happens to the disbursement of grants to autonomous states in 275 1A. Next, my lord, 279A, which is the GST amendment. I put it in summary form, my lord, in the table so that it will be a little easier for your lordships. Even in the distribution, my lord, as far as the GST applies, 279A subclause 4G says special provision, I'm sorry, my lord, where I put in my chart 279, it should say 279A, my lord. Now, my lord, 4G is a very interesting proposition. Special provision meant to be made to the states of Arunachal, Assam, Jammu and Kashmir, Manipur, Meghalaya, Mizoram, Nagaland, Sikkim, Tripura, Himachal Pradesh, and Uttarakhand.
This must be on account of geographical reasons.
Sorry, my lord?
This must be on account of geographical reasons. All these are really states.
Partly that and partly because of the nature of the states. Your lordship is right, my lord. But this can be reversed and it will be placed before the GST because it lays later on that the GST Council will look at this. Now, my lord, I come to Article 330. Very important provision, my lord. To say that special provisions can't be made in the Constitution is anathema, my lord. Now, my lord, these special provisions relate to certain classes. Scheduled caste, scheduled tribes, Anglo-Indians, etc. Special provisions are a regular feature of our Constitution. I don't want to take your lordships through this, but these special provisions exist, without which, my lord, so much could not be done for the SC, ST or the OBCs. In fact, all these commissions, my lord, they report. And when the government of the state, it has a very interesting provision that it shall be laid before the legislature of the state, explaining with a memorandum the action taken or proposed to be taken on the recommendations relating to the state reasons for the non-acceptance. This is, my lord, 338(7). This is what should be done with President's rule, my lord. Even the governor's report, my lord, was not placed. This is what has to be written in, just as your lordship with Nagaraj added conditionalities, my lord. This is what should be written into 356. You put in all the information you have, you put in the governor's report, and you give the reasons for the non-acceptance. This runs for the other commissions as well. Otherwise, my lord, 356 has become a farce. When I was doing my book on President's rule, my lord, the elaborate discussion on Kerala, my lord, when President's rule was imposed. As we come down the line, there is hardly any discussion in Parliament. Why? Because all the information is not even there. And in the case, my lord, of Jammu and Kashmir, it wasn't there. The entire correspondence, my lord. I'm just building, my lord, something that is here in 338(7), which is also for the other commissions, my lord. Something, my lord, that gives information to the people and those people who have to, Parliament that has to bless or unbless, as the case may be, my lord, President's rule. That entire cache of information, which is so fundamental, my lord, to democracy and federalism, is missing in the proclamations. Then, my lord, if I may take my lords, my lord, to an interesting provision, my lord, 330, my lord, which makes special provision for reservation of scheduled castes and scheduled tribes. Sorry?
We saw 330. We've seen 330.
Assam is mentioned, you've done that. 343, my lord. This has to be read with the 8th schedule. Kashmiri, my lord, is one of the languages recognized by the 8th schedule. Kindly just bear this in mind. So in communications, in complaints, etc., Kashmiri can be used. That has not been taken away and cannot be taken away. Part of the spirit, my lord, of a region or a state is its language. Now, my lord, your lordships, when you look at the language of the Union, a commission is appointed. (347) makes special provisions for language spoken by a section of the population. And of course, my lord, chapter 4, that's 350, has special directives in relation to language. Who is going to make those special directives now? The President? Parliament? What is the status of Kashmiri now, my lord? Does it disappear from the 8th schedule, my lord? Then, my lord, 371A, my lord, has a very interesting provision. 368, my lord, I have kind of dealt with, my lord. So I won't take your lordships to that. But 371A, my lord. It is a very interesting provision, my lord. With all this discussion on the Uniform Civil Code, these are also unamendable provisions, my lord. Just as we are arguing that 370 was unamendable, my lord, by 368, subject to a certain procedure. (371A) says, notwithstanding anything in this constitution, no act of parliament in respect of the religious and social practices of the Nagas, Naga customary law and procedure, administration of civil and criminal justice involving decisions according to Naga customary law, shall apply to the state of Nagaland unless the Legislative Assembly of Nagaland by a resolution so decides. Non-legislative power. And the same is repeated, my lord. The important provision, my lord, in 371, of course, concerns the hill areas of Manipur, very relevant. My learned friend has a point that if there is President's rule, the Legislative Assembly has this power. Can Parliament exercise it, my lord? That is why, my lord, it is restrained in 356. Now, my lord, the controversial provision in which your lordship has given a judgment is 371F, capital F, subclause F. This is Podial, my lord. If I have time, my lord, I'll take your lordship. So if not, my lord, I'll just refer to paragraphs. Parliament, for the purpose of protecting the rights and interests of different sections of the population of Sikkim, may make provisions for the number of seats in the Legislative Assembly of the state of Sikkim, which may be filled by candidates belonging to such sections for the delimitation of the Assembly constituencies, and from which candidates belonging to such sections alone may stand for election to the Legislative Assembly. This, my lord, was examined in Podial. I'll give your lordships the reference, my lord. Podial and KHANNA. Which volume is it in? It's in volume 14, my lord. The argument was a very interesting argument. Baba Sahib Ambedkar itself said in Parliament that there will be one person, one vote, apart from the reservations from SC, ST, etc. So the argument that was advanced, my lord, which led to a 3-2 decision, was that although this is their part of the constitution, we have to take the history of Sikkim into account, and reservations for Bhutias, Lepchas, and the Sangh are permissible. This, your lordships, my lord, will find in volume 14, 6350. The majority starts at 6392, my lord. Mandatory provisions respecting, my lord, what the people of Sikkim had asked for. Albeit, my lord, with adjustments to the constitution. No, my lord, while you're on it, will your lordship just turn to Cordial, my lord, because it's important to bear in mind. PDF क्या है? 305. Volume 14, 305. Starts it, sorry.
Volume 14, page
Cases volume.
30.
305. My lord, if your lordships will turn to 6394, my lord, which is PDF 349.
Where does it actually begin, the judgment? Ah, yes, I got it.
Sorry, my lord,
It begins at 305.
where it starts, my lord.
Yes.
And I am referring to the discussion in Chief Justice Venkatachalaya's judgment, my lord. At PDF 349. ठीक है, I'm on 36394, which is PDF 249, 349. Now, my lord, here, I'll go through it very, very quickly. Just the learned Chief Justice, my lord, goes from para 66 onwards to all the proclamations and discussions till para 76, my lord. '74 in particular, my lord, at page 6396. The year 1973 saw the culmination of a series of successive political movements in Kashmir towards the government responsible to the people. Then it mentions the tripartite agreement, clause 5 of which is mentioned there in para 74. And various other provisions are made. 112 hectares. Where he actually deals with where he actually says, just give me a moment. Oh, they are. At para 120, Lord.
Of the judgment?
PDF 364. Why was this, my lord, promise to the people honored despite a provision of the Constitution? And this is explained by the majority at para 120-6409. PDF 364. Para 120. What was the rationale, my lord, of respecting what the people of Sikkim wanted, despite the provision in this constitution, one person, one vote, and no vote on account of religion? The rationale and constitutionality of clause F and other provisions of the electoral laws impugned in these petitions are sought to be justified by the respondents on grounds that a perfect arithmetical equality or value of votes is not constitutionally mandated, imperative of democracy. And second, even if the impugned provisions make a departure from tolerance limits and the constitutional permissible limits, the discriminations arise are justiciable on the basis of the historical conditions peculiar to and characteristic of the evolution of Sikkim's political institutions. and the characteristic of the evolution of Sikkim's political institution. Therefore, my lord, your lordship, has been taken into the discussions that were held as far as J&K was concerned. And why it is important, my lord, particularly as I indicated, the merger agreement, which deals with internal sovereignty. Unlike, my lord, the instrument of accession, which deals with external sovereignty. Then, my lord, the last 4 lines are important. What Article of 120, 371 FF, and the electoral laws in relation to Sikkim seek to provide, it is urged, is to maintain this balance in the peculiar historical setting of the development of Sikkim and its political institution. Sikkim is the only other example we have other than Kashmir where it was entered into Manod. And therefore you take into account all the antecedent discussions and see if they make out a case, whether for 370 or otherwise. In my voice. Put some whiskey in it. Now, my lords, I take your lordships, my lord, to Schedule 5. I'll skip, my lord, the in the Constitution.
What is that?
Schedule 5, my lord, deals with the administration of scheduled areas and scheduled tribes. Some of us are not happy with the Constitution Bench decision in Chebrulu, my lord, on how you apply legislative powers. But, my lord, there's a Tribals Advisory Council. So when the governor, my lord, applies laws under 5 subclause 2, subclause 5 says no regulation under this paragraph unless the governor making the regulation has, in the case where there is a Tribal Advisory Council, consulted such council.
Where is that, Dr. Dhawan?
My lord, this is in subpara 5, my lord.
Okay.
5.5, my lord.
Consultation with the Tribes Advisory Council.
Now here, my lord, even where there is power, you must consult the Tribal Advisory Council. Then, my lord, I come to the most important article on schedule on autonomy, Schedule 5, 6. Lord, my learned friend rightly points out that Schedule 5, my lord, deals with Assam, Meghalaya, Tripura, and Mizoram, excludes them, and then this, my lord, is applied in Schedule 6. Now, my lord, we come to the question of autonomy of the Northeast, my lord. My lord, without all these autonomies, my lord, India would have collapsed by now. Because unless all this was given, my lord, to the states in question in the light of antecedent discussions, my lord, this quest for uniformity across the board, which 272 and 273 seem to countenance, my lord, is not the heart and soul of the Indian Constitution. It is autonomy within federations, special provisions in relation to people. Take that away, my lord, we don't need such a big constitution. And all the antecedent discussions, my lord, become part of these autonomies and special provisions. We can't wish them away, my lord, and say they are just history. Okay. So far, so good. Now, my lord, kindly come to Schedule 6. There is, my lord, apart from the ones that are dealt in Schedule 5, as my learned friend pointed out, this applies to tribal areas in Assam, Meghalaya, Tripura, and Mizoram. And subpara 1, my lord, is headed Autonomous Districts and Autonomous Regions. They have an in-between status between panchayats, my lord, and union territories. Now, my lord, under Article 1, Subclause 3, the governor, no doubt, my lord, with the advice of his Council of Ministers, wherever we read governor, my lord, it is rarely in his personal capacity. Apart from death penalty cases from which your lordships have ruled. The governor may, by public notification, include any area in any of the parts of the said table, exclude any area in any of the parts of the said table, create a new autonomous district, increase the area of any autonomous district, diminish the area of any autonomous district, unite two or more autonomous districts or parts thereof so as to form a autonomous district, alter the name of any autonomous district, define the boundaries of any autonomous district. This is a little akin, my lord, to Article 3. And this is where the entire politics of the Northeast, my lord, and the provisions, my lord, relating to the Northeast arise. Gorkhas say we want Gorkha land. Somebody says I want Bodo land. All this, my lord, emanates from Schedule 6 and the concept of autonomy. Then, my lord, subpara 2, there shall be a district council for each autonomous district consisting of not so many members, of which 4 will be nominated by the governor. And then, my lord, there shall be a separate regional council for each area constituted an autonomous region under subpara 2. Subpara 2 of each district and regional council shall be a body corporate with its seal, etc. What is important, my lord, is also what do these autonomous councils do? Kindly come to paragraph 3. powers of the district and regional councils to make laws. Has your lordship got it?
Schedule 6. Schedule 6.
To each of these is given a lawmaking power, with of course some limits, without which we might lose the Northeast, my lord. It is this democratization, my lord, of power that has enabled, my lord, us to make special concessions where they are necessary. Given the antecedent history, as I've explained in the case of Sikkim. Then, my lord, the regional councils, district councils and regional councils to make laws. And then, my lord, there are a series now, my lord, there are two interesting provisions, my lord, which your lordships will probably find in the footnote to the sixth schedule. That is an article, my lord, a subpara 3A. Wasn't without, my lord, protest and accommodation. Has your lordship got 3A, my lord, somewhere in the, probably in the footnote?
Yes.
Additional powers of North Kachar Hills Autonomous Council and Karbi Anglong Autonomous Council to make laws. And this includes, my lord, subject to the provisions, of course, of List 1, 7, and 52. Which interesting part, as my learned friend points out, in 371, 3AB, communication, my lord, is given to the, it says to the councils, that is to say roads, bridges, ferries, and other means of communication not specified in List 1 of Schedule 7. Now, my lord, come to 3B. Your lordships are familiar, my lord, with the Bodoland, my lord, agitation. I needn't explore that further, although we have material on it. 3B says additional powers of the Bodoland Territorial Council to make laws. And then lists on what they can make laws. Paragraph 4, my lord. I'm almost done with this diversification point, my lord. Now come to paragraph 4, administration of justice in autonomous districts and autonomous regions. Which goes on to then say, may appoint suitable persons to be members of such village councils and presiding officers of such courts. It's a little lower down, my lord, in that paragraph.
Which is the next clause?
No,
Para 4, you were saying.
I was taking your lordships to para 4, my lord.
That's the administration of justice.
That's the administration of justice. Of course, my lord, sub-para 3 says the High Court shall exercise jurisdiction over the suits and cases to which provisions of sub-para 2 of this paragraph
Yes.
apply, as the governor may for time to time specify. Even as regards the High Court.
Yes, Doctor.
Then, my lord, 121, sorry, para 12 and 12A. A and 12AA, my lord. I want to point out how in the state of Meghalaya and Tripura, my lord, autonomous districts have laws which are subject to what is equivalent to the 254 procedure. And your lordships will see in 12A, notwithstanding anything in the Constitution. Likewise, my lord, 12AA, notwithstanding anything in the Constitution. Then 12B from Mizoram, my lord, notwithstanding anything in this Constitution. It limits even the powers of the legislature.
Oh, yeah.
President's rule, where is it? No, on 370s.
Okay, we have.
Lord, the reason why I've cited all this, my lord, is because of the diversity this constitution, my lord, makes in federalism and democracy. A diversity that is to be treasured, not wished away in the name of uniformity. There are no dead horses to be flogged.
Diversity, I mean, you are right, it's possibly more diverse than the whole of Europe combined together.
Europe, America, or Sub-Saharan Africa, take parts of the South Seas. This is, and so is Jammu and Kashmir, my lord, with its history. It has its own diversities. Diversity is necessitated because of the absence of the merger agreement, my lord. So what I'm going to call this, although, my lord, in my submission, I've called these asymmetrical provisions, these are in fact multi-symmetrical provisions. This makes our constitution unlike any other in the world. Simple examples of asymmetry are Canada. You will have French in one area and English in the other. Or Belgium, the three-language formula. Those are asymmetrical. The Indian constitution is multi-symmetrical. Of which J&K is a part. For its reasons, I'll now come, my lord, straight away to 370. Much of it has been argued, so I don't have to take your lordship through all of it, my lord.
Point after lunch that.
I'm sorry I've taken some time, my lord. Because as soon as your lordship asks for a list, as you asked Mr. Zafar Shah, your lordship said, you've done with point 6, now what come to the other one? I have a list which I'll give to your lordship after lunch.
Dr. Dhawan, how long would you now take after lunch so that the next
An
person?
hour or so, if possible, my lord.
Could we cut it, possibly curtail it to about half an hour after lunch?
Yeah.
Half an hour after lunch, can we conclude it, maybe?
May not be enough now. Just give me that, my lord.
All right, 45 minutes. 2:45, we'll move on to the next.
My lord, usually arrive late, my lord. That knocks off 10 minutes.
That's why I said 45 minutes. He didn't say 2:45. But we'll be here at 2 o'clock.
Sanjeev, please.
Lordship has not eaten into my time.
Absolutely not. 2:55.
No, my lord. There's Mr. Dinesh Dwivedi's time, my lord. He took my time on technical incompetence, as I did on libraries. All that has to be adjusted. I'll do my best, my lord. I'll do my best. Because what I've done now, my lord, as I put census summary at the end, which I'll hand over like Mr. Zafar Shah did. But what I can't resist, my lord, on the diversity argument, a passage from TMA Pi, which is not in your lordship's compilation. So I've made copies. May I hand them over? Go to the other side also. Lord, I'll take your lordship straight away to para 157, which is on page 586. And just below placetum D. This is the most evocative understanding of the diversity of our constitution, apart from the two Delhi judgments which went into it in depth. Now, just below placetum D, Lord, may I just read?
Yes.
All the people of India are not alike. And that is why preferential treatment to a special section of society is not frowned upon. Article 30 is a special right conferred on the religious and linguistic minorities because of their numerical handicap and to instill in them a sense of security and confidence, even though the minorities cannot per se be regarded as weaker sections or underprivileged sections. Now, 158 is the evocative passage that I want to read. The 1 billion population of India consisting of 6 main ethnic groups, 52 major tribes, 6 major religions, 6,400 castes and subcastes, 18 major languages, and 1,600 minor languages and dialects. The essence of secularism can best be depicted if a relief map of India is made in mosaic, where the aforesaid 1 billion people are the small pieces of marble that go into the making of the map. Each person, whatever his, her language, caste, religion, has his or her individual identity, which has to be preserved, so that when pieced together, it goes to form a depiction with the different geographical features of India. These small pieces of marble in the form of human beings, which may be individually be dissimilar to each other, when placed together in a systematic manner, produce the beautiful map of India. Each piece, like a citizen of India, plays an important part in the making of the whole. The variations of the color as well as the different shades of the same color in a map are the result of these small pieces of different shades and colors. But even when one small piece of marble is removed, the whole map of India would be scarred and the beauty lost. Just over the page, my lord. Each of the people of India has an important place in the formation of a nation. Each piece has to retain its color. By itself, it may be an insignificant stone, but when placed in a proper manner, going into the making of a full picture of India in all its different colors and hues. A citizen of India stands in a similar position. The Constitution recognizes the differences amongst the people of India, but it gives equal importance to each of them, their differences notwithstanding, for only then can there be a unified secular nation. Recognizing the need for the preservation and retention of different pieces that go into the making of the nation, the Constitution, while maintaining inter alia the basic principles of equality, contain adequate provisions that ensure the preservation of these different pieces. I wanted to read this, my lord. It's a very evocative passage, my lord. Now, my lord,
Yes.
your lordship will be dealing with pieces of marble, my lord. How you deal with it, my lord, will come later. Now, my lord, may I invite my lords, my lord, to my submissions,
Yes.
which is in volume 1, page 195, PDF 195. I'm going to go at super speed, my lord, because there's a guillotine on my head, my lord. Very sharp one, I might add. Now, my lord, I'll just take your lordship very quickly. Come to the 198, my lord, page, the external, your lordship's page. Skip all that, my lord, and come to page 200, which is
Second,
PDF.
I'm not able to get.
Which file are you?
Volume 1 of the written submissions, my lord.
There's a WC. Yes, yes. Yes.
That is the submissions of all men.
Volume 2 is Mr. Sibbles, volume 1 is the rest.
Oh, I see.
I'm sorry, my lord.
190.
Your is the,
PDF page 195.
Page 195, where it starts, my lord.
195 to
There
280.
is an index which I won't trouble your lordships with, my lord,
is volume 2.
but I'll take volume 1.
Volume 1.
Volume 2 was Mr. Sybil's submission, which came, my lord, a few days late.
Article 370.
200 पे नहीं आ रहा है, वो 00 पे आ जाता है। नहीं, volume 1 पे है।
But at 200. Your lordships have it, my lord?
Yes.
Yes.
I'm taking your lordships on PDF 200 in para 1.5, because all the other documents have been read. I'm not going to repeat them. The history has been shown to your lordships. But I made a point, my lord, about why the merger agreement was important and why 370 in one sense represents the standstill and merger agreements. I'm going to read this passage, my lord, from Premnath KAUL in para 1.5. Has your lordship got it?
Yes.
Referring to the past, my lord, thus there can be no doubt that this act of 1939 marked the second step taken by the Highness in associating his subjects with the administration of the state. It did not constitute even a partial surrender of His Highness of his sovereign rights in favor of the Rajya Sabha. Even after the instrument of accession, my lord, he had not given up his rights. That, your lordship, will come over the page. I can get the PDF numbers to this if your lordship wants me, not, but it's in.
No, we've got it. Yes.
Now, my lord, dealing with after the instrument of accession.
How many judges was Premnath KAUL?
5.
No, it's. Yes, 5 judges. These are all constitution benches. Now, my lord, may I take your lordships to 1.7?
This is in relationship, in regard to the relationship of these of the Maharaja with the Praja Sabha.
This is Praja Sabha.
Praja Sabha.
I'm now building on that, my lord.
Yes.
Therefore, my lord, what actually 370 represents is two powerful democratic movements, my lord. One in the people of India, my lord, and the other, my lord, in the people of Kashmir, demanding of their Maharaja, which is eventually what he did. He gave a Praj Sabha, he wanted a National Assembly, but he didn't agree to a Constituent Assembly, which came later, my lord. Now, my lord, 1.7. Maharaja Hari Singh continued to be the absolute monarch of the state, and in the eyes of international law, he might conceivably have claimed the status of a sovereign and independent state. Because all the instrument of accession did is put in these four conditions and said externally, my lord. That's why I made the distinction between external sovereignty and internal sovereignty.
This is with reference to date is 15th August 1947, not with reference to the.
I'm coming, my lord, to the instrument of accession, my lord, in 1.
That's 1.9.
That's right, my lord, that's the instrument of accession. Immediately after that comes 1.10. Thus, by the instrument of accession, the Maharaja took the very important step of recognizing the fact that his state was a part of the dominion of India. That's all that the instrument of accession represented. We can't say at that point that he had surrendered all his sovereignty. He had not, my lord. That process began partly politically because of the political movement and partly because of 370, my lord. Because that's where we see a coming together of the Constituent Assembly, the governor, the president, all that comes together because there was no merger or standstill agreement. Now, I won't read, my lord, the proclamation of the Maharaja, my lord, of 1948, where he talks of his Council of Ministers. I'll just come straight away, my lord, to what Sardar Patel said over the page in 1.13. In view of the special problems with which the government of Kashmir is faced, we have made a special provision for the continuance of the constitutional relationship of the state on the existing basis. And it's very important to understand what 370 really represented and what the instrument of accession really did. It bound itself to India, but the rest of the process of democratization, my lord, of adjustments, of sharing of power, was never done in the case of Jammu and Kashmir. Even in the white paper, my lord, on the states, there is one paragraph which says, we are not dealing with Jammu and Kashmir. Then, my lord, your lordships will just come to 1.21. This is on the 12th of November, pursuant to a resolution of the Constituent Assembly resolving to end hereditary rulership in the state, Yuvraj Karan Singh was elected to the post of so-and-so, and dynastic rule in J&K came to an end. Now, your lordships have already been shown how CO 48 emanated from the Assembly of Jammu and Kashmir, Constituent Assembly, and became part of our constitution. This part, my lord, of your lordships, I needn't give you cross references, need I, my lord? PDF.
No, neither. No, that's
now, my lord, I'll skip the rest. 1.24, my lord, I've already read the second proviso to Article 3.
Yes, we saw.
So I won't read it again, my lord. But I come, my lord, to page 11, 1.30. Before that, my lord, just
Dr. Dhawan, just
1.25.
one thing, just more for your juniors than for you. The dates which you have given in the written submissions, if anything is missing in Mr. Sibbal's list of dates, perhaps it might be good if we have it in one place. Likewise, when the respondents begin, it would be very nice, if we have one consolidated list of dates so that we don't have to, sort of then
That's right.
shuffle between two or three
Showing
different.
Mr. Sibbal's list of dates in a separate font or separate color or something.
And
Well,
something
but
which you're adding, because I think we were reading Mr. Sibbal's list of dates, there's no innuendo in any of the lists. It's just state the date. So if you feel that, there's something missed out, then you can make track changes in that list of dates. So it'll be a little easier for us ultimately after the. Isn't it, Sanjeev?
My lord, what I'm endeavoring to do, my lord, substance to the list of
All right,
dates.
fair
This
enough.
is what I'm trying to do.
Fair enough. Then there's not.
Not just reading it as a list of dates.
Fair enough.
Now, 1.25, my lord. (1.25), my lord, on the 17th of October 1956, the Constitution of Jammu and Kashmir was adopted by the JK Assembly. All the details are given there, my lord.
Yes.
Now, my lord, this is a singular aspect of Indian federalism, to have a separate constitution for a state. For others, you gave autonomous regions, you bound them together, you expanded it. But this, can the JK Constitution of 1957 be wished away by an amendment to CO2 272, 273 and Article 3? It simply can't, my lord. So one of the big losses is, where has it? It's like Macbeth, the Thane of Fife, he had a wife, where is she now? JK had a constitution, where is it now? Has it been subsumed by 273? And when I go to 273, my lord, I'll deal with that. Now, my lord, I come to asymmetrical federalism at 1.30. Kindly change that to multi-symmetrical, as I've argued, my lord. Now, my lord, all those references are there. But, and of course, I've given your lordship a list, which I don't want, which is not repeated here. So I'll come straight away to 1.33. The importance of the Delhi decisions, my lord. I'll take up the second decision first. The Chief Justice, after reviewing the asymmetrical provisions described above in State of Delhi so-and-so in 2023, held that regard must be had to the principles of asymmetrical federalism embodied in the Indian Constitution, and that constitutional principle must be given substantive weight to this underlying principle. I'll read that paragraph. Actually, I should read it at the end, but I'll read it now. This variance in the constitutional treatment of union territories, as well as the absence of a homogeneous class, is not unique only to union territories. The Constitution is replete with instances of special arrangements being made to accommodate the specific regional needs of states in specific areas. Therefore, NCTT is not the first territory which has received special treatment through a constitutional provision, but it is another example in line with the practice of the Constitution and visiting arrangements which treat federal units differently from each other to account for their specific circumstances. For instance, Article 371 of the Constitution contains special provisions for certain areas of various states, as well as the entirety of some states. The marginal notes to these articles composed of rubric of 371 provide an overview of a number of states where arrangements in the nature of asymmetrical federalism are made in the spirit of accommodating the difference and specific requirements of regions across the nation. The next, my lord, line, para 41. I'm not taking your lordships to the PDS, my lord, because this is enough of what I want to refer to. The design of our Constitution is such that it accommodates the interests of different regions while providing a larger constitutional umbrella to different states and union territories. It preserves the local aspirations of different regions. Unity in diversity is not only used in common parlance, but is also embedded in our constitutional structure. Our interpretation of the Constitution must give substantive weight to the underlying principles. This is, my Lord, how we approach the Constitution, as has been done otherwise also. Now, my Lord, I add to this, my Lord, the huge number of precedents, my Lord, of what is called transformative constitutionalism. 1.36. The ultimate goal, that's from Navtej Singh Johar, of our magnificent constitution is to make right the upheaval which existed in Indian society before the adopting of the constitution. The court in so-and-so observed that the Indian constitution is a great social document, almost revolutionary in its aim of transforming a medieval hierarchical society into a modern egalitarian democracy, and its provisions can only be comprehended only by a spacious social science approach, not a pedantic traditional legalism. The whole idea of having a constitution is to guide the nation towards a resplendent future. Therefore, the purpose of having a constitution is to transform the society for the better, and this objective is for a fundamental pillar of transformative constitutionalism. Then, my Lord, the Chief Justice, as he then was, my Lord, in the 219 decision, my Lord, of the Delhi decision, the Constitution is a transformative document. The realization of this transformative potential rests ultimately in the ability to breathe life and meaning into its abstract concepts. For above all, the Constitution was not intended by its draft persons, by its draft persons to be a significant instrument of bringing about social change in a caste-based feudal society witnessed by centuries of oppression and discrimination against the marginalized. As our constitutional jurisprudence has evolved, the realization of the transformative potential of the Constitution has been founded on the evolution of equality away from its formal underpinnings to its substantial potential. My Lord, I cite this for a reason, my Lord. When this hearing began, my Lord, it appeared to me that we were reading the Constitution as if it was a statute. For a long time, my Lord, we were going to this word and this proviso and that proviso, my Lord. That is not how constitutions were meant to be read or to be transformed. Then, my Lord, if your Lordship will come to this question 1.41, I won't read it, my Lord, because constitutional morality is also mentioned, my Lord, in various judgments of, my Lord, the Chief Justice, when you refer to Pratap Bhanu Mehta's contribution, etc., my Lord. Now, my Lord, straight of NCT versus Union of India, if the moral values of our Constitution were not upheld at every stage, the text of the Constitution may not be enough to protect its democratic values. In order to truly understand what constitutional morality reflects, it is necessary to answer what is that Constitution trying to say, and to identify the broadest possible range to fix the meaning of the text. Constitutional morality does not mean allegiance to the substantive provisions and principles of the Constitution. It signifies a constitutional culture which each individual in a democracy must imbibe. Pratap Bhanu Mehta identifies certain features of constitutional morality, chief amongst them being liberal values which govern the making of India's Constitution, and created expectations from the polity. One of the essential features of constitutional morality, thus, is the ability and commitment to arrive at decisions on important issues consensually. It requires, despite all differences, we are part of a deliberative exercise. It is going to be my submission, my Lord, that this deliberative exercise, my Lord, has not taken place with the changes of the J&K Constitution. Now, Mr. Sibal, my Lord, had a number of questions that were asked in Parliament till the last day. Your Lordship has seen that. Are you changing 370? The answer was no, no, no. And suddenly, my Lord, out of the blue, we entered into 5th August. This, my Lord, consultation or concurrence, my Lord, is fundamental to the manner in which we read constitutions and how each provision comes into place. Then, my lord, I will just read, my lord, the NCT decision. That's the earlier one, my lord. While interpreting the provisions of the Constitution, the safe and most sound approach for the Constitutional Court to adopt is to read the words of the Constitution in the light of the spirit of the Constitution, so that the quintessential democratic nature of our Constitution and the paradigm of representative participation by way of citizenry engagement are not annihilated. This court must adopt an interpretation which glorifies the democratic spirit of the Constitution. The Constitution has mandated a federal balance wherein the independence of a certain required degree is assured to the state governments. As opposed to centralism, a balanced federal structure mandates that the union does not usurp all the powers and the states enjoy freedom without any unsolicited interference from the central government with respect to matters while exclusively falling into its domain. So this is the approach, my lord, towards constitution to multi-symmetric federalism. Now, my lord, I will take your lordships straight away, my lord, to 370. I think at some stage a question fell from your lordships. Weren't any protests made before that, my lord? I just want to take your lordships to 2.15 at page 221 external. My lord, there is a literature that could fill a library on the protests over 370. And then, my lord, the State Autonomy Committee, my lord, read this out. And of course, it goes to a slightly further extreme, my lord. But this is, my lord, the constitutional understanding, which is not too dissimilar with other federations. I won't read it, my lord. I've just pointed it out to your lordships. Once again, my lord, I've reproduced here the debates. I'm not going to read those out, my lord. Iyengar's speech has been read out to your lordships, my lord, 2 or 3 times. It's just that on page 224, whatever I've highlighted in bold, again, the government of India have committed themselves to the people of Kashmir in certain respects. They've committed themselves to the position that an opportunity would be given to the people of the state to decide for themselves whether they will remain with the republic or to wish to go out of it. We are also committed to ascertaining the will of the people by means of plebiscite, provided that peaceful and normal conditions are restored. And the impartiality of the plebiscite could be guaranteed. We have also agreed that the will of the people through the instrument of the Constituent Assembly will determine the constitution of the state as well as the sphere of union jurisdiction over the state. This is the commitment, my lord, that lies behind Article 370. Then, my lord, at the bottom of the page, till a Constituent Assembly comes into being, only an interim arrangement is possible, not an arrangement which could at once be brought in line with the arrangements that exist with other states. Now, if you remember the viewpoints I've mentioned, it's an inevitable conclusion that at the present we could establish an interim system is an attempt to establish such a system. Then, my lord, I will skip, my lord, other passages that have been read out, my lord, to your lordships. The JK Constituent Assembly, my lord, 11.21. I'm coming to page, external page 217. Sorry, 217. 227. Why is it? Sheikh Abdullah's speech has been read, but this is their understanding in the absence of a merger agreement. As I indicated earlier, my lord, the 370 is in the nature of establishing the relationships. And in that portion that I've highlighted, this arrangement involved a division of sovereignty, which is the normal feature of federation, beyond the powers transferred to it by it to the dominion. The state enjoyed complete residuary sovereignty, which is what is reflected in the JK Constitution. So, my lord, the instrument of accession says list 1, list 3, they have their place, but we have all the residuary powers. Therefore, control over the state lists, my lord, as far as they are concerned. Then, my lord, when the draft constitution, my lord, was introduced, I'm coming to, my lord, 11.25 at 231 and 232. Just at 232, my lord, just above 11.26. By this I mean that all these special constitutional privileges which our state enjoyed prior to 1953 are enjoyed by her even today. In other words, the state enjoys the same kind of autonomy which it stood prior to 1953. Therefore, to say the instrument of accession wiped things out, my lord, is simply not correct. Now, my lord, 11.28, I've already read it out to your lordships, my lord, because it imposes a limit. One question that was put, can 370 be amended or not amended? Is it there permanently? Mr. Sabal said that's not before your lordships, but at any rate, it may not have been a sufficient answer. There is a proviso, my lord, that was added by CO 48. CO 48 is a foundational document, my lord. And that is at 11.28, provided further that no such amendment shall have the effect in relation to the state of Jammu and Kashmir unless applied by the order of the President under clause 1 of 370. In other words, after you go through the amendment process. Now, my lords, can this proviso,
Somebody's cell phone triggered.
what has happened is, my lord, when the microphone was on, some things emerged there which I didn't want to emerge because I was talking to my colleagues. I hope they will be excised.
But that's what I went to him and told him that your whispers are also being recorded.
My lord, we will deal with all that, my lord,
शाम को बोलो निकाल दें.
with a pinch of salt, my lord.
But it's quite accurate, huh?
I shudder to think, my lord, if this was the case when we were arguing Babri Masjid, what would come in the transcript? Such a huge amount of exchange took place, my lord. Now, my lords, therefore, my lord, how do you amend the 370? You amend it through the 368 process. But there was in CO 48, my lord, a provision that you will then go to 370 and follow the procedure in 371. And that's very important, my lord. Your lordship asked, what was lost on the 4th of August? This is something that was lost. And they didn't even use the amendment power, which is the only power available to them, my lord, to delete 370, not the circuitous process that they used in 272 and 273.
Yes, Dr. Sir.
Now, my lords, on 235, 11.32 onwards. My lord, your lordship conferred, that took time as well. Happy though I am that your lordships did, my lord. My lord, I'm going to be super quick, my lord.
Yes.
Just give me that indulgence. Now, my lord, here are all the cases. Your lordship needs to go through Premnath KAUL, which I've summarized, my lord, in 11.33. Because it actually explains what the situation was after 1950. When there was an instrument of accession, but no merger agreement. On page 236, my lord, my submission, my lord, from Premnath KAUL is application of 370 of the Constitution to the state of JK also does not impact the plenary powers of the Maharaja. The form of the Constitution to be applied to JK was a matter left to be determined by the State Constituent Assembly, and until such decision was taken, the constitutional relationship between Union and the states was governed by the terms of the IUA. So the internal, my lord, relationship had to still be determined under 370. Now, my lord, an argument has been made on the basis of Puran, Lakhampal, etc. What is the meaning of modification? And they say it's very wide. But, my lord, your lordship has to read it in context. And that is when the matter was not referred to the 7-judge bench, my lord. Your lordships took the view that please read these decisions in context. Don't read them outside the context. Now, my lord, I'll come to 370, my lord. What I've done in the meanwhile, my lord, is done a short page and a half, my lord. But I'm not giving it now because your lordship may introduce the guillotine earlier. Now, my lord, kindly come to 370.
Does that begin at 239, Dr. Dhawan?
Sorry, my lord.
Is that? Oh, sorry.
Where
I
on
thought you were referring to your submissions.
My lord, I'm not going to repeat what's in the submission.
All right.
I'm going to just, my lord, stress what is not in the submission,
Fair.
which I've stressed orally.
Fair. Yes, Doctor.
No, my lord, we need not be troubled with temporary provisions at all, my lord. That has been the great, my lord, call. This is a temporary provision. It's temporary to the extent that 370 indicates. Therefore, my lord, in my personal view, my lord, 370 subclause 2 and 3, which deal with the Constituent Assembly, my lord, have become motives. They have invoked this, my lord, in CO273. All of a sudden, a provision, my lord, which is constitutionally beyond the extension of the Assembly, has suddenly been used in CO273. That, and I think it's CO44, is it? 44 is the only time, my lord, 370 subclause 3 was used. In 1952, and now, my lord, in the year 2019. So, my lord, what remains, my lord, after the Constituent Assembly? In our submission, what remains is 370 subclause 1. Not to be read as a statute, but to be read in context. And what are the provisions here, my lord? I'm not going to read them out, it's been read ad nauseum, my lord. It says, follow the instrument of accession, my lord, as far as consultation is concerned. For the rest, there must be concurrence. And the same is true, my lord, of D, 371D. Those provisions, my lord, are governed by the two provisos. Which then talk of consultation and concurrence again. The reason why I said, my lord, that 370 could not be tinkered with during President's rule is because there is a mandatory requirement, as it was in Article 3. About consultation and concurrence. You can't say we wiped out the Constitution, we wiped out all the treaties, so that 370 is gone. Amend it, go through that particular process. But by this circuitous route, my lord, mandatory provisions which survive in 370 subclause 1 are violated. And they can't be done under President's rule for a very simple reason. Because it says the state government, my lord. Consultation with the government of the state is declared by the President to correspond in such matters. Other matters in such list with the concurrence of the government of the state. Of course, provision 1 in this article shall apply in relation to the state. And then, my lord, once again in D. Now, my lord, can we wish this away by some circuitous route? 370, by far from being a relic, my lord, is in fact what is there in the merger of agreement read with the instrument of accession. In fact, my lord, I say this is part and parcel, my lord, of the multiple federalism that exists. You can't use these provisions, my lord, without subjecting them to the discipline of Article 370. And that's what Damnu, my lord, Damnu, your lordship will get the also says you can't do it. So, my lord, I come back to my broader proposition that while President's rule was in operation, you could not use Article 3 because you can't substitute like one legislature for another. And you can't, my lord, do away with 370 for a very simple reason that mandatory provisions of the Constitution do not say that Parliament can do this and the President can do this. It says it must be done by the government of JK, which is not, my lord, the ersatz government of JK, but in 272, it says with the Council of Ministers. And that is fundamental to the operation of any government. So you don't do it with the Council of Ministers. Can you do it simply, the way it was introduced in Parliament by Mr. Amit Shah, that you simply do it by saying, we're using 370 and this is how it's done. In President's rule, my lord, it cannot be done. There is no tearing hurry, my lord, in our Constitution to say that the amendment power can be used and abused whenever you want it to. I'll show you the. My lord, I want to show quickly two decisions, my lord, on why the merger is separated from. It is in volume 6, my lord, of the cases. And the case is Pramod Chandra Dev. It's at page 1587. PDF. And I want PDF 144. The steps that were required. And I'm saying that this, in fact, is in a sense, my lord, the merger agreement is really what 370 is. Now, my lords, I take your lordships to page 1596.
Dr. Dhawan, which volume?
Sorry, my lord, volume 6. Cases, volume 6. Item number 10, page 1587, PDF. 135. It starts at 135, and I'm taking your lordship to 1596 at 144. My lord, this is in para 10, on page 1596, my lord, the bottom of the page, my lord. This was, my lord, some.
What PDF page will that be actually?
144.
144.
It says of the instrument of accession, Lord, in the last 5 lines of page 1596. Does your lordship have it? This accession, that is, instrument of accession, did not affect the continuance of sovereignty of the rulers entering into the agreement, save as provided by or under the instrument of accession. So there was no external sovereignty was lost, my lord, but internal sovereignty, my lord, remained where it was. And then, my lord, going over the page at 1597, my lord, 4 lines from the top, the second step was the signing of what has been termed the standstill agreement, the form of which appears in the white paper. And the acceding state signed the standstill agreement which provided for the continuance in time of all subsisting agreements and administrative arrangements in the matters of common concern between the states and the Dominion of India. The first phase of the process of integration of the Indian states into the Indian Dominion was the accession of the states as aforesaid. The second phase followed on the merger of the states into the Dominion of India as a result of the merger agreement. Now, there was no merger agreement, my lord. So where was the merger agreement, my lord? Either we continue the sovereignty, it was said, my lord, in Premnath KAUL, or we say that this is the essential step by which, my lord, internal sovereignty and internal arrangements are worked out. Then it says, my lord, a little further down, But 4 lines below that, my lord. As a result of the merger agreement signed by the rulers of these states on or after 14th December, but before the 1st of January 48, the Dominion of India was vested with sovereign powers, and the ex-rulers were left only with their private property and their annual privy purses. This was the effect of the merger agreement. And it's all there in the white paper of the states, my lord, which I don't want to go into. So where was this loss, this arrangement of internal sovereignty worked out? In Article 370, my lord. The only 2 other states were Hyderabad and Junagadh, my lord. They stand on a footing of their own. And that is why, my lord, I emphasize that 370 is the repository of the merger agreement read with the instrument of accession. In this very volume, my lord, I want to refer to one other, which is the first privy persons case, my lord. It starts at
PDF.
It starts at PDF 390. And I want to take your lordship straight away. Of course, the amendment came later in taking the Privy Persons Amendment power away.
Page 3.
So, my lord, we're still on volume 6, my lord, and I'm taking your lordship to PDF 457. Just one small paragraph. Paragraph 111 on page 1909. PDF 457.
Referring to paragraph 11, Mr. Awad?
May I read out, my lord? Para 1 and 111.
Yes.
The plea raised by the union must be considered in the light of these developments. The political developments and the history of negotiations and agreements were certainly not intended to be an exercise in futility. The argument that the parties to the instruments were entering into a solemn undertaking intended the arrangements to be temporary and likely to be set at naught by the unilateral act of the Union of India must be rejected. This is building on Mr. Sibbal's argument, my lord. A unilateral act, my lord, the assumption you don't take into account history. So the argument raised by the union that this is an exercise in futility going back, the response is the argument that the parties to the instruments were entering into solemn undertakings intending the arrangements to be temporary and liable to be set at naught by the unilateral act of the Union of India must be rejected. Submission, my lord, which I will hand over and go through it. One of my arguments, my lord, whether it is done by transformational morality, my lord, because of the antecedents, or whether it's done by basic structure, or which transformational morality, in my view, is a part. That 370 to that extent is part of the basic structure. As a substitute for the merger agreement, as an interpretation, my lord, just hand over that. $356, my lord. Where is it anyway? My lord, I'm coming back to volume 1 of the submissions. The PDF number is 267. My lord, I put in a table to show how President's rule has been exercised and Section 92 has been exercised. My Lord, it is my respectful submission. They cannot be exercised in tandem. As it was, my Lord, Governor's rule had taken place and now President's rule was imposed. On that, my Lord, if your Lordships will see, I've given, my Lord, all the cases that I want to cite. I won't bother your Lordships with them. Except, my Lord, page 276, which is PDF 276, 4.25.
I'm sorry, Mr. Nahal, what are you referring to?
Lord, my submission.
Your written submission.
I'm now winding up, my Lord,
Page number
mercifully.
270.
276.
276.
An important aspect, my Lord, Bomai, of course, is there. You can't remember that in Bomai, my Lord, it was just the action of Presidents. 32 was not involved in the same extent. But I'm relying on 4.25, Rameshwar Prasad's case. Has your Lordship got it, Lord?
Yes.
It is open to the court an exercise of judicial review to examine the question whether the governor's report is based on relevant material or not, whether it is made bona fide or not, and whether the facts have been duly verified or not. This, my Lord, is what your Lordships have indicated on the extent of judicial review. Now, what has happened in this case, my Lord, and your Lordships, my Lord, as a Nagaraj can lay down conditionalities for the exercise of 356. All the documents must be made publicly available and placed before Parliament. In this case, even the governor's report, my Lord, was not placed before Parliament or before the court. So when your Lordship, my Lord, says 356 is justiciable, what are the contours of this justiciability? A full, frank, and complete disclosure to Parliament and to the people. Just to say that this is, I've received this message, there it is, and not even to place the report. That is why I say, my Lord, the entire exercise of President's rule needs to be examined by our Lordship in this case. Others will argue, my Lord, more on this when their turn comes. Now, my Lord, I'm going to give your Lordships my summary, my Lord. Give it to the other side. Because this, my Lord, is the substance of what I've added to my written submission. May I read it out, my Lord?
Yes.
India has a multi-symmetrical constitution to be interpreted as transformational in nature. It's unique. And that is why your Lordship insists on these transformations, despite the many amendments, despite the length. This is a multi-symmetrical constitution. My second submission, the instrument of accession represents, subject to conditions, the loss of external sovereignty. However, standstill and merger agreements finalizes the internal sovereignty arrangement. And that, my Lord, is to be the internal sovereignty arrangement is to be found in 370. 370 is the result of a binding historical agreement. The instrument of accession deals inter alia with conditions of external sovereignty, but in the absence of standstill and merger agreements, 370 represents a substituted, constitutionally consecrated measure agreement for finalizing internal and external sovereignty, resulting in two interactive sui generis constitutions, unlike any other states. It is unique and part of the basic structure entrenched in democracy and federalism. For basic structure, my lord, read transformational constitutionalism. 371 alone survives, and 372 and 3 have exhausted their invocation. Why is this important, my lord? Because, my lord, after 1954, the first time 373 was used was in 273. The provision is gone, the Constituent Assembly is gone, and the substitution is for the Constituent Assembly, the legislature of the state. How can you resurrect, my lord, 370 subclause 3 all of a sudden, years later, after the assembly is over and there is a JK constitution? Now, my lord, as far as the width of power under 1D is there, my lord, is subject to constraints. I needn't say more than what has been said before. It's subject to its two provisos, and for the rest of the Constitution, consultation and concurrence. Now, my lord, Article 3, 4 and 370 contain mandatory requirements on information to be laid before the House and inter alia requiring concurrence and consultation. Unfortunately, the mandatory requirements of Article 3 for sending the bill to the legislature was suspended by the presidential proclamation of 19th December 2018, which is ultra-vires and taints both the declaration and the extension of President's rule in 2018 and 2019. Then, my lord, on President's rule, the President's rule provisions of 356 and 392 and Section 92 of the JK Constitution can not be imposed in tandem. 3 and 4 and 370 cannot be invoked during President's rule at all, since they require the existence of a legislature and state government, for which the President and Parliament cannot be constitutionally countenanced. Then President rule as required by S.R. Bomai and Rameshwar Prasad is justiciable, requiring objective basis, which includes the governor's report, and all material should be placed before the people and Parliament justifying itself.
Formulated it well. Sara, unka jo. No. I was just telling my colleague that you have really summarized very precisely all that you have argued. We've taken down what you have argued, but now this formulates
We
it.
read it out, Manoj.
Certainly.
And then I'll sit down. And that's a promise. Now, my lord, Article 370. So I've said all the materials, my lord. Article 370 can be amended, subject to the caveat in CO 48 that all amendments relating to JK must follow the procedure in Article 370, subclause 1. It is not enough in 273 says all treaties are out and the Constitution is gone. How can a Constitution disappear like this, my lord? Many federations, my lord, have two state constitutions, and JK, because of its nature, my lord, did. Accordingly, 272 and 273 are invalid as being excessive, and the JK Reorganization Act 2019 under 3 and 4 as going beyond the mandatory provisions and in violation of the process of Article 3, wrongly suspended by the presidential notification of 19th December. Now, my lord, I ask, my lord, answering your lordship's question, what was lost in
Yes.
4th of August?
That's point 9.
Mr. Zafar Shah, my lord, will give your lordships a detailed account.
Itemized list.
This is my summary account. What was lost? The loss of statehood by degrading it to union territories. That was lost. Indirect abolishment of the JK Constitution. Loss of residuary power. Loss of territory contrary to the JK Constitution, Section 3. Section 4, sorry. Abolition of mandatory, informatory, concurrent, and consultation provisions. Conversion of statehood into union territories without adequate safeguards, especially for JK and Ladakh. Constitution without a proper amendment and consultative process and concurrent procedure of Article 370, for which CO 48 was added to 368. The right of permanent residence of JK on their right to property and to vote. Because 31, my lord, Article 31 was not suspended, only the later Article 31 remained. In the light of the above, it is pleaded, restore statehood to JK, permit the continuance of the JK Constitution, have immediate elections under the JK Constitution, abrogate presidency. So this is what I have to say. I'm sorry I've stepped over my time.
Thank you, Dr. Dhawan. Thank you very much, Doctor. Yeah.
Allow me to begin with this, Lord, profound words of Justice Aaron Barak, Lord, the President of the Israeli Supreme Court. Lord, he was reported in Harvard Law Review as way back in 2002. Since, Lord, we are expounding Constitution, these are extremely apt words. And I quote him, the task of expounding a Constitution is crucially different from that of construing a statute. A constitution is drafted with an eye to the future. Its function is to provide a continuing framework for the legitimate exercise of governmental power. Now, Lord, 370 is perhaps the most brilliant, Lord, articulation of statesmanship on the part of the constitutional framers. You are at a time when, Lord, calls for plebiscite in Kashmir are being raised. You are at a time when raiders are raiding, Lord, in plain clothes and trying to take away. You are at a time when Maharaja is uncertain whether he wants to join the dominion of India or Pakistan. You are at a time when, Lord, India is just being born as a, Lord, dominion nation. At a time like that, Lord, it was a brilliant compromise that was arrived at, which, Lord, led to, Lord, producing this article, which persuaded the people of Jammu and Kashmir to accede to India. We gave them a promise. You cannot, Lord, breach that promise in the manner that you have done, or for that matter, at any point of time. And that's why, Lord, what Dr. Dhawan very rightly points out, that, Lord, ultimately, each, Lord, article of the Constitution, Lord, deals with this kind of diversity, which, Lord, if we were to start tinkering with, then, Lord, nothing will be left of the Constitution. So, Lord, your lordships may have to consider, Lord, and my respectful submission, three, Lord, submissions. One, that Article 370 is a piece of, Lord, unusual, Lord, draftsmanship. It is temporary, but it is not temporary by efflux of time as most temporary statutes are. It is temporary by object, the purpose. Once that object is achieved, once that purpose is subserved, then, Lord, nothing remains for the president to exercise. So, Lord, it's going to be my respectful submission that 373, Lord, has served its purpose. The day Constituent Assembly of Jammu and Kashmir agreed that yes, Article 370 must remain on the Constitution of India, subject to following modification, and President accepted and issued that modification in CO 44. That's the end of the story. Lord, your lordships have taken the view right from federal court, and I will show Lord series of judgment that temporary statutes, Lord, General Clauses Act does not apply. If that is so, then Lord, the exercise is one-time exercise. You cannot exercise it again and again. It was never intended to be exercised again and again. Now, if it is not a continuing exercise on a demurrer, in my respectful submission, then Lord, the only way Parliament could do it is by amending the Constitution under Article 368 and repealing Article 370, and in no other manner. And I will show, my Lord, that's the view, Lord, 8 of your lordships have taken in Berubari's case, where your lordships, Lord, interpreted a treaty and said that you cannot do this unless you amend the Constitution. And lastly, it's going to be my respectful submission for your lordship's kind acceptance that the exercise of powers by the President on 5th of August and 6th of August 2019, Lord, are nothing but fraud on the Constitution. As Dr. Dhawan rightly points out, there is nothing on record why a provision which has successfully survived from 25th October 1947 till Lord 6th of August 2019 should have been Lord repealed, as they claim, or should have been withdrawn. There was no material whatsoever. The only material with respects was that Lord, the ruling party in its manifesto in 2019 had said, we will abrogate Article 370. Your lordships in DC Wadhwa's case have said that you cannot exercise constitutional powers to achieve political ends. Lord, it's a classic case of fraud on Constitution. So, Lord, you have a government in Lord association with a local party in Jammu and Kashmir. It is working well. You suddenly withdraw the support from that government. Then you persuade the governor to issue president to issue a 356 order. Then you persuade president to issue a resolution of the assembly. You, Lord, Parliament then apparently takes control of legislative and executive functions, and then you say, now President will exercise all powers into one and Lord pass orders under 370. Lord, what more classic example of abuse of power than this can be? Lord, as Chief Justice Coke said, Lord, way back when the fight began with the king, that Lord, king can do everything except making a man a woman and a woman a man. Lord, surely President could not have exercised these powers under 373, assuming himself to be everything. What Lord has been pointed out at great pains and very brilliantly, that Lord 356 is a temporary provision. Now, Lord 356 being a temporary situation, can you take actions which are permanent or permanency or permanent in nature? Forget anything else. Because Lord 356 itself says that everything that you have done in the interregnum will come to an end. And maximum period for which you can exercise 356 is 3 years. So, Lord, to do this, Lord, in my respectful submission, it really strikes at the very basic features of our Constitution. Democracy, federalism, Lord, Government of India in their affidavit before your lordships categorically admits this, and this is very important, Lord, the counter, which I'll read at Lord appropriate stage, that Constituent Assembly of J&K did not in any manner deviate from the provisions of the Constitution of India, which would be applicable to J&K. This is their Lord profound statement. Then Lord they try and Lord they say that Lord ultimately that what we have done is because of national interest. Therefore, nobody knows what this national interest is because it's not been defined in their counter affidavit. There was no material whatsoever. As I said, Lord, it has survived. Of course, there is insurgency. Nobody can deny that. But then we have insurgency in so many states in Northeast India. We had insurgency in Punjab for a long time. If we were to start not disintegrating states into union territories in this manner, no state will be safe in this under political class that we have today. Tomorrow it may so happen that my party cannot get elected in a state. I will disintegrate into union territories because there is law and order problem. This is something which your lordships will have to very seriously consider. It's not just one-time exercise. It has such broad ramifications for future of India, for the Constitution of India, for federalism, for very existence. That Lord, it will really be giving now this kind of a power to Lord, a majoritarian government will be destructive of rule of law. It would be terribly destructive of rule of law. And I beseech your lordships, that's why in KOHELO, your lordships have Lord, very beautifully put it, that constitutionalism demands that your lordship should oversee every act of the parliament and the executive. And the moment your lordships will find that there is infraction of constitution, your lordships will come down heavily on them. It's all right to create this atmosphere of fear all around. Nobody brought one thing, I must tell your lordships, very interesting, Lord, very few people, Lord, way back on 27th May 1949 in the Constituent Assembly, Lord, a debate was going on about bringing 4 representatives of J&K who had not been invited so far. Question was whether they should be nominated or not because everybody felt that they should be present. So Lord, Mr. K.T. Shah, who was an advisor to government of Jammu and Kashmir and who had Professor K.T. Shah had worked there very extensively, he made this statement which was very interesting, which was perhaps quite inappropriate. He said, it has been the declaration of highest authority of India and also that of accession of the state made by the Maharaja, who was the complete constitutional head on the day that accession was agreed to, was subject to confirmation by result of plebiscite. Now please see Pandit Jawaharlal Nehru's retort to that. Jawaharlal Nehru retorts by saying this is absolutely incorrect, 100% incorrect. I am amazed, surprised and astounded that such a statement is made by Professor Shah. Why? Because Kashmir had certainly become part of India and it will always be a part of India. Nobody denies that. Article Section 3 of the Jammu and Kashmir Constitution itself provides that we are part and parcel of India. Question is that when you have now, as your lordships have very rightly questioned about sovereignty, you can acquire a new land by either accession or by cession or by occupation. In each of these cases, you can take away complete sovereignty, as my Lord the Chief Justice observed. But what happens in a situation like this, where you have agreed as a nation, as a dominion, as a state taking over that territory, that I take your territory subject to this condition. What happens then? There, Lord Derubari says that you cannot now get out of those conditions. And the only way you can do it is by amending the Constitution of India. Now, you don't want to amend the Constitution of India because then you have to follow the procedure. You need 2/3 majority in both houses. You may even need, my lord, to go to the legislatures of the state because you are taking away representation of the state in Lok Sabha and Rajya Sabha. So you will need, my lord, 50% of the states to agree to that provision. So, my lord, these are the safeguards. If these safeguards are thrown out of window in this light manner, who else can protect except your lordships? So, my lord, it is very therefore important for us to understand that, my lord, this is not just about Jammu and Kashmir. Jammu and Kashmir was, is and will always remain part of India. But, my lord, the promise that India made to Jammu and Kashmir, the cession which came about on terms and conditions, how do you interpret those terms and conditions? So, my lord, your lordships are called upon to expound this constitutional provision, which in my respectful submission is, and I must tell your lordships that Premnath, first, your lordship said that yes, we have to await the confirmation by the Constituent Assembly. I will show those passages. Then in Sampath Kumar, your lordship said, Constituent Assembly has given that assent. People have agreed to abide by this, and President has accepted. So both ways your lordship's court in these two judgments will not give a complete finality to what is the eventuality under Article 370, sub-Article 3. So, Lord, in my respectful submission, this calls for a very different kind of approach than what government of India would like your lordships to take. Lord, that's an extremely, I would say it's a narrower approach. That's not how constitutions are interpreted, Lord. They have to be, these are durable provisions. They must go through the test of times. If merely because something has happened or is happening in Jammu and Kashmir, you have to do this, then Lord, it may happen in another state and you might be called upon to do that again. So, Lord, the power cannot be exercised because of, Lord, certain situation prevailing at a particular point of time. Constitutional provisions can't be tinkered with in that fashion. So, how do you make them durable? You make them durable by really understanding. But the need of the hour was that we wanted Kashmir to get into us, Jammu and Kashmir. So, Lord, at that point of time, we were left with no option but to accept what they offered us. Otherwise, we were afraid Maharaja might run away to, Lord, there was one fear that he might go to Pakistan. He might join Pakistan. So, Lord, nobody knows what exactly was happening, but who were the people who really were aware? The constitutional framers. And Lord, Dr. Iyengar's exposition of 370 is really the complete answer. Although, Lord, I am conscious that Constituent Assembly debates may or may not be, Lord, relied upon as Lord, but it gives a complete answer to what government tells us on Lord 370. He also says that all that we need is the wishes of the people expressed through a Constituent Assembly. Once that wish is expressed, it's the end of the matter. He says that, and I'll read that two paragraphs of this. So, Lord, whichever way one looks at this provision in my respectful submission, this controversy needs a very, very delicate approach from your lordships, so that we do not end up creating a situation. Today, let us assume for the sake of argument that today this decision is in national interest. Let us assume for the sake of argument. Tomorrow, some other political party in power with majority may try and take a decision which is not in national interest. You have to therefore lay down law which will stop all these exercises for all times to come. And that's where constitutionalism comes into play. And I beseech your lordships with all humility at my command that your lordships may therefore look at it this way. Now take therefore in this regard, kindly turn straight away to one judgment of your I have a compilation of judgments which are new, but you can also, Prasanna, you can add them. We can. It is already with Prasanna. I can add them with just in 1 second if your lordships permit.
It's part of the existing compilation now.
It's not with your lordships, it's with the learned courtmaster, volume 30. 130 case law. 130. Case law
So
compilation.
what is volume
From the-
29? Yes, we stop at volume 28.
29 and 30 have not been allowed by the chiefs.
These are judgments only.
Judgments are in the compilation?
Dr. Baba says.
Mr. Dave.
Sorry,
Mr.
sorry,
Dave.
Mr. Dave,
No.
I'm sorry.
Many of them are, but 5 of them are not. Which, Lord, your Lordship knows, Lord, our research goes on all the time.
That's it, Mr. Dave, but at some point of time, you have to freeze it all, otherwise, you
These are
know.
judgments. Your Lordships can't certainly stop us from
Why not
fighting
wait?
judgment.
But we had-
Submissions, yes, I agree. But
But
Lord,
even
these are-
judgments, should it not be frozen when you submit written
No,
the
it's not easy.
compilation?
It's not easy to do it. Let me tell your Lordships honestly, because this is a thinking process. We are constantly thinking and constantly rethinking and rethinking and rethinking. Lord, to find 5 judgments, I have seen more than 500 judgments. I can assure your Lordships.
If we apply this principles to ourselves on the lighter side, then we'll keep on thinking, not produce any judgment, and keep on thinking only.
Lord,
All
your
that will
Lordships,
happen.
Lord, your Lordships, once the matter ends, certainly will be thinking many a times over.
Yes, but we see.
But at some time, we have to also say, all right,
So,
now,
Lord, that's.
this is the guillotine, now I'm not going to think anymore.
All right, when my arguments are beginning.
All right, but if so many of your judgments are repeated in the compilation already.
I am not repeating,
So
those
then
are
give-
there, those
then
are
five-
there,
Which
which
are
I am
the
not.
5 judgments which are not in, then
Yeah.
just the judge. We can give them.
Judgments which are already given, I am not.
Actually, the back office work has to be done before the argument.
Much before the arguments, you know, otherwise it becomes
So
impossible.
the way the problem is, if you are a singular counsel arguing.
Lord, once the debate begins in the court, your Lordships put questions.
You know,
So,
Mr.
Lord,
Dave, what happens is that's why if we don't do this, essentially difficult matters will never get argued because the whole purpose is to restrict time. If you don't restrict time, we cannot carve out time for big matters.
I have promised 1.5 to 2 hours, I'll finish it. I am not going to take.
My concern, Mr. Dave, if you were the only counsel, it doesn't really make so much of a difference. Because you added something, subtracted something. When the multiple counsels, 10 counsels, 12 counsels, each person starts doing it, where do we go? This is the concern only. It is not that we wanted to shut
Law
out. this-
declared by this court, my Lord, your Lordships would always like to see. It's law declared by your Lordships court, my Lord.
No, but I mean, there has to be a certain procedure also and orderliness in making.
Every year, SEC online creates some 19, 20 volumes. This is another problem.
Well, I'm sure, Lord, when your Lordships directed us to give submissions, we never thought that, Lord, so far as judgments are concerned, because it's a constant research. Nobody can, Lord, do it at one go. You are trying to find out again and again and again answers. Questions fall from your Lordship's, Lord, bench. So, Lord, to that, your Lordships rightly asked about sovereignty.
Volume 20. 2 volumes, Ms. Dave.
I don't know, 29 is by.
29 is Mr. Nowadays. That has also not been allowed by the board.
This is the problem. How can we do this?
Then how many volumes will we have actually?
It is
We
endlessly-
should be actually having
Problem.
1 volume now of case law.
28 is
My 28 was allowed already earlier, but 30 is not an additional one. How many judgments? do you want? 30. I have brought printed copies also, if your Lordships like.
So volume 30 is 5 judgments.
5.
29 also has just case law, right?
Yes, yes, my lord. There are no submissions. These are only judgments. You know. 28, 29, 30 are case law compliance.
All right, you can.
No, my apologies for it, but my lord,
What sauce for the goose is not sauce for the gander. So you will not.
I'm sure my lord, Mr. Mehta will definitely like to cite my lord new judgments to
I
counter
don't
us.
think so.
It is-
He's not saying that I'm going to cite it. Don't give him ideas.
Lord, his smile tells us otherwise, my lord.
My learned friend has signed.
What is it that you want to cite? All right, Mr. Dave, let's quickly run through it. Give us, give us those, why don't you give us the soft copies? Huh?
It's in the drive.
यहाँ पर है। Judgments or?
No, yes, my lord, I would like to.
That you want to, why don't you then give the judgments in 10 minutes that we have today? You can really give us the framework. What are the judgments you want to cite? What is the principle? Just formulate the principle.
As I said, my lord, the three points that I want to urge. One is that my lord, 370 by itself, my lord, is a self-exhausting provision.
All right, then what are the judgments? Just tell us the citation. Volume 29 page.
My lord, 1959.
Volume 30, right? Volume 30.
PDF,
Just give us the PDF page.
my lord, PDF page 16161.
No, it can't be 16161.
Page 2. Of volume 30, page 2. You proper page. You sit down and give.
Volume, what is the site? What is the name of the
This
case?
is Dalmia Dadri Cement versus CIT. But this interpreted this very broad letter of accession and said that this is a treaty. And more,
Para?
yes, more paragraph 3, 5, and 8. 8.2.
8.2.
Yes.
Why don't you read out the relevant part, Mr. Bell?
Yes.
Let me read it out.
So, my lord,
Yes.
now, my lord, here, your lordship say, and I what fell from the Honorable Chief Justice.
What did it interpret? Interpreted?
Sorry?
What did it interpret, you said?
Lord, interpreted the accession agreement and Lord held it to be a treaty and then said sovereignty should transfer.
Sovereignty transferred.
Yes. But my lord, in the subsequent case, my lord, in Berubari, which is already on record.
Now, Berubari, where will we get the citation?
Yes, my lord, Berubari is at, my lord, I'll tell your lordship.
Which case law compilation?
PDF page.
Of volume?
Yes, my lord, it is PDF page 13, CLCP 492.
No, what is the volume?
13, page 492.
Volume 30 or 32?
13.
Volume 13, page?
92. 492.
Let's
Now, Lord, this will have to be read in extenso because this is a brilliant, Lord, exposition of a treaty and why, my Lord, your lordships held that you cannot get out of this treaty except by constitutional amendment. Give me the page when I interpret the resolution.
Volume 30.
Don't ask.
Volume 13?
I am Lord. Your lordship knows, Lord, that Mrs. Dave had to assist me. Your caused embarrassment to your lordships at that point of time. Lord, my Lord, that's why I proudly call myself technologically.
It's so simple, Mr. Dave. Just give it a try for one day and you'll never go back.
Try to encourage you on the lighter side by saying I had an equivalent mind block to it. And among the mind blocks I had, I used to tell the chief, see, don't deprive me the privilege of, after a miscellaneous matter, throwing the file down. That's the only privilege a judge has after a badly argued matter. But but in these kind of matters, I mean, having done it last time, I realized that the volumes become so many in a small matter, it's fine, but in a bulky matter,
No,
it
no,
works
this-
better.
This is the thing.
It works better.
Now,
So we are
there's no doubt
encouraging you,
about-
Mr. Dave, that please get on board.
Well, I am giving your lordship PDF pages.
But that is what your junior is relaying to you. You have to give it to us yourself.
I don't know that word, I don't take away, please from me.
Volume 13, page 492. Berubari.
Yes, Vinod. I turn to. In view of our conclusion. Yes. Lord, Lordship. What para 31? My lords have got it. May I read it, please? What then is the nature of the treaty making power of a sovereign state? That is the next problem with which we must consider before addressing ourselves to the questions referred to us for our opinion. As we have already pointed out, it is essential attribute of sovereignty that a sovereign state can acquire foreign territory and can, in case of necessity, cede a part of its territory in favor of a foreign state. And this can be done in exercise of its treaty-making power. Cession of a national territory in law amounts to transfer of sovereignty over the said territory by the owner state in favor of another state. There can be no doubt that such cession is possible, and indeed history presents several examples of such transfer of sovereignty. It is true, as Oppenheim has observed, that hardship is involved in fact in all cases of cession the inhabitants of the territory who remain lose their old citizenship and are handed over to a new sovereign, whether they like it or not. And he has pointed out that it may be possible to mitigate this hardship by stipulating an option to emigrate within a certain period in favor of the inhabitants of a ceded territory as means of averting the charge that inhabitants are handed over to a new sovereign against their will. But, now see me not these words, and I place them for your lordship's acceptance. But though from the human point of view, great hardship is inevitably involved in cession of a territory by one country to the other, there can be no doubt that a sovereign state can exercise its right to cede a part of its territory to a foreign state. This power, it may be added, is of course subject to the limitations which the constitution of the state may either expressly or by necessary implication impose in that behalf. In other words, the question is to how treaties can be made by a sovereign state in regard to cession of national territory, and how treaties, when made, can be implemented would be governed by provisions in the constitution of the country. Stated broadly, treaty making power would have to be exercised in the manner contemplated by constitution and subject to limitations imposed by it. Whether the treaty made can be implemented by ordinary legislation or by constitutional amendment will naturally depend on the provisions of the constitution itself. We must therefore now turn to the aspect, that problem, and consider the position under our constitution. In dealing with this aspect, we are proceeding on the assumption that some legislation is necessary to implement the agreement in question. Then lordships may omit 5-7 lines and please come to the words unlike other federations.
But before that, something very interesting. The Attorney General, appearing for the Union of India, in that case, argued that there is something called the basic structure.
Correct.
Just see that the learned Attorney General asked us to bear in mind the special features of the basic structure of the Constitution.
Correct.
In construing the relevant provision of Article 3. He contends that the basic structure of the Constitution is the same as that of the Government of India Act 1935.
That's how, not right, 60. 60,
Yes.
60. Mr. Setalwa, he alone could do that. Now please see, Lord, unlike other federations, the federation embodied in the said act was not the result of a pact or union between separate independent communities of states who came together for certain purposes and surrendered a part of their sovereignty. The constituent units of federation were deliberately created, and it is significant that they, unlike the units of other federations, had no organic roots. Hence, in the Indian constitution, by contrast with other federal constitution, emphasis on preservation of the territorial integrity of constituent states is absent. Now, my lord, this is important. But now, my lord, kindly turn to paragraph 44 at page 515. How does it begin? Yes.
Just read the lower portion.
Yes.
Also.
Just read what, my lord?
The paragraph 32, the lower portion.
In fact, you can start reading
Yes.
from, in fact, it is well known, and then go to the end, as my learned brother says. In fact, it is well known. Last 10 lines. Is it directly goes against you?
That as a result of States Reorganization Act in place of original 27 states and one area which were mentioned in Part D in first schedule to the Constitution, there are now only 14 states and 6 other areas which constitute Union territory as mentioned in first schedule. The changes thus made clearly illustrated the working of peculiar and striking feature of the Indian Constitution. There may be some force in this contention. It may therefore be assumed that in construing Article 3, we would take into account the fact that Constitution contemplated changes of territorial limits of the constituent states, and there was no guarantee about their territorial integrity. Undoubtedly. Question is, can they be turned into union territories? Of course, they can be changed territories. No difficulty. That's express provision. And note the word, if your lordships were to read the word union territory for every word state in Lord Article 3B, then Lord result will be absolutely very unbelievable. So Lord, although the explanation says that state includes union territory, but if you were to read it,
Mr. Dave, I didn't want to interrupt, but if it can be done for the state, why not for union territory until unless there's something you can make out otherwise, and when the explanation goes, explanation says state and union territories use interchange.
Lord, I must tell you, Lordships, I am not dealing with that part of the argument which has
That's
been
fine.
very beautifully
Okay, then we
done
come
by
down.
my worthy predecessors. But Lord, I must tell you, Lordships, that what is really worrying me is this. Your Lordships are right, it can be done. Question is that, Lord, if it can be done in Jammu and Kashmir, why can't it be done in Gujarat? Why can't it be done in Maharashtra?
Okay.
So, Lord,
let's
that's
move further.
something which
Let's
you
proceed.
have to bear in mind. It
Let's
can't
proceed
be
further.
done. Now, Lord, please turn to para 44, straight at page.
L15.
Therefore, our conclusion is that it would not be competent to Parliament to make a law relatable to Article 3 of the Constitution for the purposes of implementing the agreement. It is considered by learned Attorney General that this conclusion must inevitably mean that the law necessary to implement the agreement has to be passed under Article 368. Then, my Lord, 368 is extracted, and then your Lordships may kindly turn to, my Lord, page 516, para 47. On the other hand, now, my Lord, this is very important. Just see, my Lord, how your Lordships were viewing, my Lord, democracy. On the other hand, it's to be passed under Article 368. It has to satisfy the requirements prescribed by the said article. The bill has to be passed in each house by a majority of the total membership of the house and by a majority of not less than 2/3 of the house present and voting. That is to say, it should obtain concurrence of a substantial section of the house, which may normally mean the consent of the major parties of the house.
Well, it will come tomorrow.
So, Lord, look at it this way. Your Lordships not construe even majority, not to be major parties of the house,
Now,
meaning that you must carry everybody on board.
After this, we have Mr. Dwivedi will be arguing, or Mr. Nafik. Right. Between the three of you, if you could please request that, could you apportion the time so that, by lunch tomorrow we have completed with Mr. Dave, Mr. Dwivedi and Mr.
Said 2 hours, but I'll finish in 1.5 hours.
So Dave, could we do this? Maybe if we give an hour to Mr. Dave, 10:30 to 11:30 tomorrow, then Mr. Nafade about half an hour. Would that be all right? Would
Require at least an hour.
make it?
Each one of us have his own nuance. I will see that overlap is minimal, but some overlap is bound to be there, can't be here. So besides not faced with the situation with the not against the other.
What we were thinking was that by tomorrow, because tomorrow is Thursday we complete one side, so that then next week the other side can open. So Could we?
continuing on Friday also.
No. Friday is miscellaneous. So if you could, in the evening today, just as you step out of the court, Mr. Dave, Mr. Nafade, Mr. Dwivedi, and Mr. Siu Singh,
Friend here.
Mr. Gopal, I don't know, Gopal
Lord, I am also appearing in the
moving forth
matter.
behind many of the arguments which have preceded him. And then Dr. Menaka.
Lord, I am appearing in the matter.
So, the 6th of the Learned Council, if you could just meet for 5 minutes after we rise, between all of you, so that, we wrap up by tomorrow on this side.
My friend invites us to a coffee.
Not possible.
Absolutely. Interveners may give us short one-page written submissions on both sides, so that, interveners can give us one-page written note on both sides. So we will not hear interveners on this side and interveners on this side. We'll have written notes of arguments, I think.
But I must point out on this side, except the government, rest are interveners. So they may be.
But then, my lord, we have, just as the petitioners challenge it, we also have an interest in seeing, my lord, that the
All right, we'll see tomorrow. But what we'll do is, please do sit down tomorrow between yourselves.
Intelligence is required in a matter like this.
So Mr. Parekh is also there. So between yourselves, if you could just apportion time so that, we are not, we don't really err in the side of giving someone more than.
I think your lordships will have to give us Tuesday. Considering the amount of seriousness with which my distinguished friends, Lord, all of them have been.
All right. We'll give you up to Tuesday. But tomorrow tomorrow, if you could please do this, that you can give us now exactly how we'll finish our wrap up with by Tuesday.
Kind of.
So just 5 minutes, if all of you sit down on this side after we rise, it'll help.
Absolutely.
Thank you. Certainly.
Deeply obliged.